All right. Mic check, mic check. 1 2 1 2. We are back today for some more Johnny Depp Amber Heard coverage. It's been fun watching the trial in the morning. It's actually been really interesting. John O'Brien, John, get up on in here. I sent you the link, and you and Nick both have the link to come in. For those of you who are new here, my name is Nate the Lawyer, and today we're just continuing with the coverage of Johnny Depp trial. So for those of you who know how this is going to go this morning, we generally watch the lunch break, and then I'll head over to Legal Byte stream, Nick's stream, or some of the other lawyers who are streaming it to see what they think about what happened in the morning. But this is my little time to just kind of see kind of how everything is works in the morning, and just give my opinions and be able to just watch the stream and give my my opinions kind of free and clear. Oh, hey, what's going on, everybody? Good morning, all. Good morning, all. Good morning, all. Woof. So I'm thinking everybody's pretty much baked into their coverage. So this is just this is really just a chill stream. We're just having just a great time watching this debacle. So first, let me start off with where we're at right now and why I think today is probably one of the most pivotal days in the trial. So let's talk about it. So we know that the defense only has 4 hours remaining. 4. But there are 3 days of trial testimony left, right? We got Wednesday, we got Thursday, and today we have Friday. What does that mean for us? Well, what that means is that if we don't get what we need to get today, we're done. We're done, right? They literally will have no time if they don't get certain information out today. So let me go back. For those of you who haven't been watching the trial from the beginning, understand what's going on. At the beginning of the trial, the judge gave each side a particular amount of time to try their case, to present on their evidence, to cross-examine witnesses, the whole shebang. I think it was maybe 60 something hours. So the judge then keeps track of that time, allowing each side to know how much time they have left. So now, going into the last week, Johnny Depp's team has going to the last couple of days, they have about 16 hours left, and the Amber's team only has about 4 hours left. But the more interesting part of this legal quandary is what they have to accomplish within 4 hours. So just let me understand. They have to accomplish these 2 major pieces of of this litigation. They got to accomplish these 2 goals within 4 hours to at least win the case, or at least try to win the case, right? These are pivotal things that they have to do. I don't care whatever legal show you're watching. I don't care whatever live stream you're watching. There are 2 things that her team must accomplish to have a chance of winning today. Sorry, I think my nose is itchy. Number one, the first thing they got to accomplish is tying Johnny Depp to the Amber Heard's alleged defamatory statement. So for those of you who don't know, Amber Heard is also suing Johnny Depp for $100 million in a counterclaim. Her counterclaim is dependent upon being able to prove that Johnny Depp made defamatory statements about Amber Heard. We don't have any evidence that Johnny Depp made any defamatory statements about Amber Heard. We don't have any evidence of that. What we do have evidence of is Johnny Depp's attorney making defamatory statements about Amber Heard. So Amber Heard wants to say, because that's Johnny Depp's attorney, the statements he made that was defamatory to Amber were really made by Johnny Depp. So that's how they're trying to link it. The statements Johnny Depp's lawyer made, to defamatory statements he made to the press, it was really made by Johnny Depp. And it was made on Johnny Depp's behalf. So since he's Johnny Depp's employee, he made those statements so we can get Johnny. So that's the crux of her lawsuit. And that piece, that connection between Johnny Depp's lawyer and Johnny Depp ordering him to make those statements is what her case is about. Is a statement still defamatory if it's true? No, if it's true, if it's true, it's not defamatory. Great question. If it's true, it's not defamatory. But what we're talking about now is not whether it's but what the issue here that they have to get over now is whether or not. Let me make sure I get this up first. The issue that they have to deal with, essentially, people, whether or not they can attribute the statements made by Johnny Depp's lawyer to Johnny Depp. Now, in any other employment scenario, right? Let's say if Johnny Depp's lawyer wasn't his lawyer. Let's say he was his TV repairman. And Johnny told the TV repairman, hey, go make these statements to the Washington Post. And the TV repairman goes and makes those statements. And then they say, who told you to make those statements? And he says, Johnny Depp told me to make those statements. You got him, right? There's no privilege between Johnny Depp and his TV. There's no TV repairman privilege, right? You can't, those statements aren't protected. But this is not his TV repairman. This is his attorney. So when you come to his attorney, then statements that he's made to his attorney are privileged, are extremely privileged. Let me bring John in. John, I'm just giving my overview of the case. Welcome to the show.
Thank you very much.
So those statements between Johnny Depp's attorney and Johnny Depp are privileged. So when it was a TV repairman, you could bring the TV repairman in, say, give me your, did you say these statements? Did Johnny Depp tell you to say these statements under oath? And he's got to tell you under oath whether it happened or not, right? There's no TV repairman privilege. But when it comes to attorneys, there is attorney-client privilege. So the statements about Amber lying, about Amber being a fraud, about all this stuff, these were all in the process of getting some legal, this is all in litigation, right? He was in a tough divorce, and this was his attorney, and he's telling them, yeah, she's fraud, she's lying. So all that is stuff relevant to the legal action, right? If he told him that, I don't even know if he told him that, but if he told him that, that's all in the process of litigation.
Even if he didn't, it's technically the attorney's choice whether to reveal information or not based upon the circumstances. The privilege is held by Johnny Depp, but the attorney has some leeway to determine whether to reveal things.
Yes.
Depp himself has an absolute right to reveal whatever he said.
Yes.
But I can't imagine that he would actually do that.
No, I don't think. Well, it's going to be objection privilege. Objection privilege. That's what I would be objecting all day. Objection privilege. So that is the issue that comes down to the Johnny Depp privilege issue. So now his attorney, you can't. So the question that has to be answered is: did Johnny Depp order his attorney to make these defamatory public statements? Now,
I can't imagine that he actually made the order.
But it's not about if the question is not the issue. It's, do you have any proof that this happened? So generally you look for an email, you could put the lawyer on the stand, but
all of this is privileged communication.
This is the problem. Look, lawyer, you're right. Put the lawyer in the stand, privilege, right? Let's get an email from Johnny into his lawyer, privileged. All of those communications. So there is absolutely no legal way that you can show that Johnny Depp told his lawyer this information. Why is this important?
I can't think of one.
Why is this important? Well, Amber Heard today, this morning, right? This morning has to prove some connection between Johnny Depp and Johnny Depp and his attorney making that statement. They have to show some legal connection.
And that's
they
what we
haven't
were
done
about
that
yesterday. That's the causation element of any sort of tort.
Yes. So this is such a problem that yesterday I expected them to put on some information, because you need that to even give it get it to the jury. That's what you need. You need that connection. If you don't get that connection, then the judge says you haven't put on enough evidence to show that this claim is possible. You should go sue the attorney but you can't sue Johnny Depp because you got no evidence to show that he to attribute the statement to him, right? Remember,
Precisely.
one of the elements in defamation is, did the defendant actually say it? And
Right.
if you don't have any evidence that the defendant actually said it, your defamation claim goes to the trash. Does that make sense, John?
Yeah, no, and I think that's their biggest hurdle right now, because they brought on the damages expert yesterday afternoon, which she was, I don't want to go into it. She was a dumpster fire.
Oh, yeah.
But they at least have a scintilla of evidence to survive a motion to dismiss, but they have never been able to establish causation.
No, they have never been able to establish that causation. And without that, if they rest today, that if they were to come this morning and rest their case and say, we rest our case, they would essentially lose the trial.
That would be one of the rare cases where you'd see a directed verdict.
Yes, in terms of her counterclaim. So
yes.
now we were talking. Let's pull it up. Now we were talking earlier. It's interesting. We were talking earlier. The trial hasn't started yet. As soon as it starts, we'll pull it up. We were talking earlier about the two things. So that's 4 hours, and now you still got to get that one, right? You still have to get that one. You got to prove that. But now in 4 hours. So that, I'm assuming, could take at least an hour, right? Well, because I don't even know how they're going to prove it. But whatever they do with that, that's taking at least an hour.
They've got 4 hours and 9 minutes left.
Yes. So I'm saying that getting that information in front of the jury takes it. That's priority number one. Because without that, your claim is dismissed. Then you got part two of this. Let me pull this back up. Amber's coming into the courtroom. So now you got part two. Remember, I told you they have 4 hours to do two things. Number one is do that. Here's number two. They then have to defend against the rebuttal case. That means they got to cross-examine witnesses. They need time to do that. Johnny Depp's team has 16 hours. They have 4. So that means they only have 1 hour. If it just stopped right now, they have 1 hour for every 4 hours that Johnny Depp's team puts on witnesses.
They don't have any time anymore to call experts or waste time. They don't have a shot in hell. They put themselves up against the wall based upon the time limits. Yes.
So,
and my understanding is that this judge actually keeps those time limits.
It's hard.
Yeah.
So I really need people to understand. Today, they can. I'm assuming they can only in the morning. They got to put on whatever they're going to do in the morning, or they've
got one witness left.
Yes, in the morning time. They. I don't think they go past lunch. If you go past lunch, they are screwed. So in this morning time, if they do not put on Johnny Depp or somebody to prove the agency, essentially they've conceded their counterclaim. They've conceded the counterclaim. And if they put on any other witnesses, they are just cutting into their own clock. So, John, before we get into this, let me knock down these two super chats. I want to ask you, what would you be doing first thing coming out the gate here? Because we got 2 minutes. So, Broly Power Maximum says, aren't the statements seemingly true though? Yes. But that's a question of fact for the jury. Are these statements true? We're talking about, but the question here with the statements are, did he even make the statements? Right? So we haven't even gotten to the point where we're evaluating whether the statements are true or not. I can't sue someone for defamation if they never made the defamatory statements. I can only sue the people who made the defamatory statements. So even if they're true, we don't get to even that evaluation because you can't just sue. I can't just sue you and say you defamed me without proving you've made the statements. That's where we're at. So I think you're right. As a question, they are true, but I don't even think we get to that question because I got to first prove that you even made the statements. This is Sean said, what are your thoughts on whether the judge will allow Amber Heard more time to cross if they run out in order to prevent appeal? You and Uncivil were talking about this last night. What do you think?
So we were talking about it. In order to prevent an appeal, and that is ultimately what a trial judge's goal is, I would grant some piece of time, but you can't grant a lot because otherwise you're being prejudicial toward the other side. You're being unfair toward the other side. And so there's a limit in what she can do because she made it very clear from the beginning how many hours each side had.
Yes.
And if you use them, you use them. Like, that's kind of on you at that point. It's not the judge's doing.
Well, I want to ask you, because as a litigator, me thinking coming into this day, my plan would be this: kill the counterclaim. Counterclaim is gone. We're not winning the counterclaim.
Yeah, let that go.
That's got to go.
Start from the premise that that's gone.
Now,
you wasted yesterday doing that.
Yes. Now I got 4 hours, but it's that diminishing returns, right? We did this whole day of this, and now what do we have to do for it? So it's not muted. It's there. We're waiting from the start.
Yeah.
All right. Good morning.
Here we go.
All right. It's my understanding that defense is resting. Is that correct? All right.
There
I'm
it
not gonna
is.
bring the jury out just
There
to
they
take
go.
back
They
things.
didn't even
They had to rest.
When after we finish our motions,
They have to
when they
save
come
the
out,
4 hours.
I'll let you say that.
They have to save the
yeah,
4
okay,
hours.
let's
Yeah.
just do it that way. All right. So based on them resting, you have a motion? And I did receive your memo ahead of time, so I have reviewed
They had
that.
motion to dismiss the counterclaim.
Okay.
Yeah, it's got to go.
Okay.
It's got to go.
Yes,
So
sir.
here he is.
I haven't received anything from them. I don't know whether they.
I think it's just gonna be
Thanks.
oral arguments.
So here we go. The oral arguments for the counterclaim. The counterclaim's got. If the counterclaim goes, it's going to be
Good
crazy.
morning, Your Honor.
Here we
May it
go.
please the court, Ben Chu for plaintiff.
They're going to ask for
Johnny
dismissal of the
Depp.
counterclaim.
Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my
There we go.
motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the
Okay.
standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3
Of Waldman's
statements
statements.
that Mr. Waldman
He's
made
right.
prior
Yes.
to being served
He's right.
with the counterclaims in this action,
Causation's
which
broken.
we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week
Say it more
that she was
clearly.
planning
It's
to
an
call
easy
Mr.
thing
Depp.
to argue.
in her case in chief. And it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson.
He's going to end with his
390
best
US
argument.
Supreme
These are
Court,
all weak arguments to
727
start
and
with.
731.
Yeah,
Your Honor,
that's
the
why I was
evidence
wondering where he's
shows
going with the actual
that
malice.
Ms. Heard
Because
cannot
this whole
prevail
thing
in her
is
claim
causation is the
because
whole in
she
the
cannot
argument.
and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation
Yeah, these are
and
just the weakest
reasonably
arguments.
reasonably
He's ringing the
believed
bells,
the three
but
statements he made were true.
Yeah.
Ms. Heard presented
I don't
nothing,
really like that tactic. What do you
nothing
think, Nate?
to contradict that undisputed fact. Ms.
I feel
Heard
like
has
get in
no
there with your
evidence
best
of
argument and
direct
just let it go.
liability, because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting
that's where
that she
that's
has no
the bomb right
evidence
there.
of direct liability
Yeah.
and cannot prove actual malice by Mr. Waldman when making the three statements at issue. It is undisputed that Mr. Depp did not make any of the three statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated,
Respondeat.
or otherwise
You have to
authorized
prove
Mr.
that, and they
Waldman to
did
make
not.
the statements at issue. There is no such evidence on the record that
There you
Mr.
go.
Depp directed or otherwise
There's no-
authorized
absolutely
Mr.
nothing.
Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his
Yes.
employment
That's the
as
respondeat
or
standard.
agency on behalf of Mr.
superior.
Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was sued, served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint, and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here, there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr.
For
Waldman.
those of you who are getting this straight, we
Vicarious
just were talking about
liability
this.
is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. C. Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp versus
PR
Allstate,
is outside the
236
scope of
Virginia,
a legal
152 at page 156.
Mhm.
Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp versus Holbert case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. And Mr. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know
It's
Mr.
a technical
Depp
argument, but it's
at
a
the
really good
time
one.
of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that two trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forms at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devanere, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F Sup 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman
This
is,
is a
as a matter of
brilliant
law,
motion
an
argument.
independent contractor, and Mr.
This
Depp
is
cannot
intense.
be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan out companies have issued him a W-2. And Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding in an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e.
Yes, they're all
any reader of the British tabloid,
she's rested her case,
made by a competitor against another, could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view
relax
about events
Listen
that
to
he
the
never
arguments.
claims to have witnessed. And there was no
Did you
doubt
get it
about
right?
that. Turning to the second part of the argument, which will be more
Welcome
abridged,
to our life.
Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc.
Shoot, don't go into fact questions.
You
You had it
better
on the
not.
law.
To Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. What he is suing about here are the three statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU.
This is a weird
And he
fallback
made it
position.
also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion. But like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here. And I would object because I think making an argument not to you, but to the cameras, it's disrespectful to everyone's time. And it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank
argument.
you.
Thank you.
Thank you, Your Honor.
Let him say his
Entitled to his
speech.
argument.
As I was trying to say,
He's got 16 hours.
what Mr. Depp is suing about are the three statements. And
16
it's
hours.
very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean,
For anybody just
adding the
motion to
gloss of
strike
public
Amber Heard's
policy
lawsuit.
might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who was not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about, that was either a reference to this game they were playing with the op-ed, or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
God, I hope it leads
Just-
okay, it's not lit. It's not lit. Thank you.
Let's see. So now we'll know after this.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the
Chat
counterclaim.
is right.
That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent.
So let's
He
hear
made
it.
those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016.
Okay.
He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the three statements in the counterclaim.
Right after this.
Your Honor has heard evidence. I won't go through all the evidence, but Your Honor's heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements.
Wow.
As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument. On the actual malice argument, the evidence shows that not only was Mr. Waldman Mr. Depp's agent, that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their
Falsified
theory
evidence
and
to
what
the
they
agency.
wanted to
I don't know.
achieve.
He hasn't pointed to any evidence.
As Your Honor
of
well
that,
knows
though.
too, I won't go through all the law,
Just
but
point to the
both
evidence.
agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which
So
the
you said
jury
he-
could
he
infer
inferred.
those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney client have a principal agent relationship.
defense of his
And
claim.
as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021
So
opinion
pre-evidence,
that the
we
statements
ruled one
are
way,
as a
so we
matter
need
of
to do it
law
again.
regarding matters of public
That's
opinion.
not how any of
The
this
court has
works.
already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the
That's
intent
your
element
argument?
of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows the jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, testimony of Josh Drew, testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that
See, all
she
this
covered
is
Ms.
irrelevant,
Heard,
though, because it's really about the
Ms. Heard's
agency
bruises
theory.
with makeup on
But I
right after
understand
the
he's got to
December
touch on 'em,
15th
but
incident that
This
provided
is not what's going to lose him,
ample
the
testimony
counterclaim.
to support that Ms. Heard often would cover her bruises that were caused by the plaintiff in this case,
I
by
actually
Mr.
think the
Depp,
judge is
with
going to keep
makeup.
the counterclaim.
He ignores the evidence
just
of Christy
because it's
Sexton. He
cleaner for
ignores
her.
the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of
She
these
shouldn't,
witnesses and
on the
others
law,
have testified
but-
extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical
What
abuse,
evidence
emotional
do you
abuse,
have to show
psychological
that he
abuse,
was that
verbal abuse, Your
he
Honor.
made these
Mr.
Give me
Depp's
a
own
causal
writings,
link.
recordings, pictures, and videos
Anything.
confirm that. The list goes
And you
on.
did not
The
do
only
There's
thing
that.
is
abundant
he
evidence in
is
the
his
record,
lawyer,
Your
so
Honor,
they're
from
saying.
which the jury
He's his
could
lawyer,
and
so.
again we believe will find
So what?
that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice. And based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to
If
answer
you
any
mailed
questions
me
the court
$1,
has.
That's
But
fine.
I'm your lawyer
Thank you.
now,
Yes,
and
sir.
I start spouting off
got a
nonsense.
little
Your Honor, I will be brief in
You're not
deference to the court's
responsible for
time and the
that.
jury's time. What Mr. Rottenborn said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO.
He should hammer at the
And when the Me Too folks say,
Agency
why
is
are
where
you
you
taking
win.
$7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship. and that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient. In a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of
this is his argument. This is the
argument.
Gamesmanship.
When Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh,
this is a good argument.
Woman, I only hit you, I didn't punch you.
This is a good
And when
argument.
it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is
You're
that
objecting to an
Mr.
argument?
George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right, thank you, sir. All right, in this
Yes,
matter,
we
I've
have
reviewed
advisement.
all the defendant's
Hold on, hold
evidence
on.
as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are
Amir,
outside
get
the
ready to
motion to
cut this
strike,
up.
and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike.
Mhm.
Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike.
Outside of scope,
The
yeah.
opinions argument, the court has already ruled on this matter as to the three statements that are issued in the counterclaim, ruled that they were not opinion at the demur and at summary judgment.
Yeah,
So
you had
that
to get
argument
out. Yeah.
will not be
She's
part of
right.
the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike.
Yeah.
Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances.
Mhm.
When there is no direct evidence, circumstances may and usually are relied upon to determine whether an agency relationship exists. A
Mhm.
principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises
I
from
think she's
their
going to
agency
let it go to
relationship,
jury.
is enacted in part to service the
Yeah, she
principal,
is.
the principal can be held liable for the
It's-
tort.
she's made it
Here, the
clear.
alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made.
Is
Mr.
that
Waldman
enough?
does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency
Yeah.
relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as
Yeah,
such.
that's nothing.
As to actual malice, Mr. Waldman
Yeah,
made the
it's enough.
counterclaim
It's over.
statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not
She
my
wrote
role
this
to measure
well
the
before the
veracity or weight of the
arguments.
evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder.
Yes.
So therefore, the plaintiff's motion to strike is denied.
There it is. Yep.
Thank you.
Denied.
Is there any other preliminary matters before the
So this
jury?
is a scintilla of evidence.
Okay.
Yeah, it's an extremely low bar, but she wrote that well before anybody
Yeah.
actually made an argument.
She knew it was coming down. So just so everybody understands where we're at, the judge has allowed Amber's motion to go forward. She says that there were a couple of things that the jury could infer. Number one, there was a meeting where Johnny and his attorney met with the Daily Mail. And in that meeting, allegedly, maybe some of those statements were made, some of those defamatory statements. So they can infer from that meeting that Johnny Depp, that he was working on behalf of Johnny Depp, and the fact that he was doing all this stuff within this litigation. So the inference that, yes, This attorney was working on behalf of Johnny Depp when he made these statements can easily be made. He was going to meetings. He called the Rolling Stone before the attorney called, like all those type of things. It's a reasonable inference that could be made. So that's what she's saying. She said it's not just because he was an attorney. It was because he was an attorney and doing all these things during that representation. So I think the judge got it right. If that's the case, and he went to the Daily Mail and sat down with his attorney, and an attorney made these statements, a reasonable person could say, you're in the room, you're with the attorney, he makes these statements, he's obviously making them on your behalf. And does anybody really believe that Johnny's paying this attorney millions of dollars to go to the meeting with the Daily Mail to make those statements not on his behalf? Right? That's what I think is going down. John, how you feel about this?
That's a tough one for me, because I agree with you with everything that we know. I think the judge probably got it right. I don't think that Amber's team proved that in court. And that's the one thing that bothers me a little bit.
Yeah, I don't think they put on any evidence that to show that, like, but this is, the judge said there's something here. It's possible. And judges get it wrong. That's why we have appeals courts. That's why we have appeals courts.
They didn't even ask the judge to take judicial notice of the fact that he did all of these things. And so she's injecting evidence into the case that was not brought by the parties. And that just always, it happens, and it's a real thing. And, you play by the rules that you got. But that one just bothers me a little bit, because I feel like she injected evidence that was not brought by the parties.
That's true. I don't remember even hearing that they were at the meeting together. This one says, hi guys, can someone sue for defamation if you don't have damages? Yes, it's defamation per se. Defamation per se, you don't have to have damages. Sometimes in the liability phase, you can prove up damages, but defamation per se, you don't have to prove your reputation was damaged, nor do you have to prove that you actually suffered any damages because of the nature of the statement. So defamation per se, yes. And even if what they said or wrote was a lie. So yes, so it being false is not that's one element of 5 elements for defamation. So it being a lie is the first element, right? Is the statement false? But then you have other elements. For instance, with this one we're talking about, was it said by the plaintiff? Did Johnny Depp say the statement? If he didn't say the statement, you don't got a defamation suit. Was it about the plaintiff? If you don't have that, it's not. Was it so those other pieces you also have to check. Those are the boxes you also have to check to have a defamatory statement. So to answer your question just consistently, yes, you can sue someone for defamation even if you don't have damages. And yes, even if they said the statement or wrote it, if it was true, if it was false, that's not the determinative factor on whether you can win a defamation suit.
Nate, I apologize. I gotta run. I gotta be out of this Airbnb by 10. So I will see you. Hopefully, I can hop back on.
Yeah. I'm gonna be here till lunch break. All right. Thanks, John. Thanks for stopping by. Let me read this next one. This says, this is hard for judge, not enough to keep counterclaim round, but if she dismisses it, it would be detrimental to AH. Yes, it would be detrimental to AH, but the judges, I think, found a way around it. And to be honest with you, listening to the judge's reasoning, I agree. I would have dismissed it. Because they haven't put any proof on of that connection. But I think the judge is right. I think the judge says there's a shot. There's some hope. And now they're going up. Now I think the argument, which we're seeing now on screen, is one in which the Amber Heard's team was like, we only got 4 hours left, and we just survived a bomb, and now how are we going to do this, right? 4 hours versus 16 hours. What are we going to do? So I think that's what they're arguing about now. Like, how do we move forward with this? Michael says, how soon will the judge rule on the counterclaim? She just did, and she ruled in favor of Amber Heard. So the counterclaim is going to the jury. Question, Nate, can you explain what impeachment of a witness actually means? Essentially, it's a witness who's on the stand now who says something, right? I went to McDonald's, and they may have went to Burger King. So you would impeach the witness by saying, well, you didn't go to McDonald's, you actually went to Burger King. And you can bring up like prior testimony or whatever where they said something different. That's impeaching the witness. Impeaching the witness is a tool that attorneys use to try to show the witness's credibility is low. When I mean by credibility, it doesn't have to show the witness is lying, but maybe the witness didn't remember everything properly, right? You were there, but you really didn't have you couldn't see everything correctly. You didn't hear what you thought you heard, right? So you're challenging the witness's credibility to determine if what this witness is saying, you can rely on it to make a decision. So that's what impeachment does. Impeachment is one of those tools to show, well, this witness hasn't been either consistent or has said something in the past that we want to let the jury know, so they can be able to judge this witness's credibility based on what they're saying or what they've said also in the past. Dr. Cataclysm says, why is the judge ruling with a Virginia law on a lawyer from California talking to a national paper? Well, that's because one thing that in law, it's this is a little more complex of a question, but just try to knock it down. In the United States, we have 50 states, and each one of those states is like a different country. And then we have the federal government, which in of itself is like a different country. So, like in this case, a lot of the things that happened in California, but the statements were actually published in Virginia because the Washington Post has the printing press and everything to print the statements up and send them out in Virginia. So what this allows you to do is you could go to Virginia and sue, saying, hey, this is where the statements were made. And then when you're suing in Virginia, they can use law. Even they could even use California law if some of the stuff arose in California. But essentially what you're doing is you're taking those facts and everything that happened all around the world. We've heard about stuff that happened in Australia. We heard about stuff that happened, on a private island. We heard about stuff that's happened. So all that information that happens everywhere, you bring it to Virginia where the plaintiff is suing, and they run it through Virginia law and say, okay, based on all this evidence, can you win this defamation suit under Virginia law? And that's what we're doing here. Oof. So here, I don't know, because now the game now is for Amber's team is precision. It's precision. Let's just be honest. Amber's team has to try to figure out two things. Number one, how to use this time effectively, because they only have 4 hours and you still got maybe 3 days worth of testimony, right? How do you spread this out? So I think they've had to change their tactic from being like this hammer to being more surgical. They have to be more surgical because now you got 1 hour for every 4 hours the other side has. So it's not responding to everything. You have to really, really be able to pick and choose what you need to get and what you don't need to get. So I got to pick and choose. Do I get this witness, or pick and choose? Do I wait for this witness? Or if they're going to put Johnny Depp on last, do I save all 4 hours for that? Right. So it makes your litigation strategy extremely, extremely difficult, especially going into these last couple of days, because you don't know what witnesses they're going to put on. You don't know really well, you know what witnesses they're going to put on. You just don't know what they're going to say and how damaging it's going to be. And if you're forced to respond to something that's just really damaging or something that's really hurt your case, that's time you've lost. That's time you've lost. So right now for them, it's a time game. It's just like with in NFL game or NBA game where time is a factor. When you're at the end of the game and you got a little bit of time, you have to be really, really precise with what you're doing. And that's what Amber's team has to do. I don't know if they can do it. I'm not confident that they can be as precise as they need to be to overcome this time issue. It's just a lot. Question. Can someone make defamatory statements but admit to it being false after the fact? Can that party be sued for defamation? So if someone makes a defamatory statement but admits to it being false, as soon as you admit to being false, you have actual malice, right? And you have defamation, but it's all going to depend on the statement, right? So if it's a false statement of opinion, pretty much no. If it's a false statement of fact, because that's what a lot of people don't understand too. False statements are not enough. It's got to be a false statement of fact, not a false statement of opinion. For instance, a good example of that is George Zimmerman. George Zimmerman from Trayvon Martin, he sues everybody for when they say he's a murderer, right? He always sues. He's suing everybody for calling him a murderer. But he always loses. He loses every time. And why does he lose every time? Because they say, it's my opinion that he is, it's my opinion that he's a murderer, right? Based on the evidence, it's my opinion. That's different than me saying George Zimmerman is a convicted murderer. Convicted murderer, that's a false statement of fact. That's not my opinion. That's a fact. I'm saying that's a fact. That's false. And that's the difference between me making an opinion. I think he's a murderer based on the evidence I saw. I think the jury got it wrong. That's my opinion. But if I say a jury convicted him of murder, that's a false statement of fact. And now we got the issue. So I want to make it very clear. False statements, you need a false statement, but it really depends on what type of false statement it's talking about. Here is Exiled. That says, are there any limits in court cases? At Nate the Lawyer. Are there always time limits in court cases? At Nate the Lawyer. Yes, they are. Well, I'll say this. Because I've done a lot of most of my trial experience or experience I have in the courtroom is in criminal court. I've never had a clock in criminal court, right? I've tried cases, I've done arraignments, I've done grand jury, I've done it all. And I've never had a judge says, you only got 5 minutes. Has there been times where the judge has said, last argument or hurry up and wrap it up, that type of thing? Yes, but never an actual time limit. I've been in some civil cases, but most of my civil cases don't really go to trial. So I'm not speaking in front of juries. If I file any paperwork, that's actually even pretty rare too. But I've had to file some papers. And even in that case, you don't really get a time limit here. But I'm assuming in a case like this, where you have a lot of evidence, you have a lot of stuff, maybe they don't want this thing to stretch out for 2 years. So maybe that's when you get time limits. So I just personally have never experienced it. I was asking a couple other attorneys. Some of them have never experienced it too. But maybe this is just something common in Virginia, or whatever. But I just personally never had the experience of the time limit. And I would suspect so in criminal cases, maybe 400 or 500 cases I've been associated with. And I've never had one time a judge say, you only got 15 hours or something like that. It just never happened to me. This question from Ryan says, what do you think Johnny's team is trying to get across to the judge right now? I don't know, because right now we're going into rebuttal. So I'm assuming rebuttal is coming up, and Johnny Depp's team has 15 hours, and I'm assuming that the other side is trying to figure out if they can get some more time, or what's the implication of what's going on, like how are we going to work it through? And I think that's where they're at now. So we'll see. Thank you for the $5. I think the judge is great on objections, but keeps throwing Amber bones. Her DV record door has been all but axed. She shouldn't be adding evidence. Well, I don't know. This judge has been pretty fair, and these rulings of motion strikes really generally go down hard. But this judge is saying that you can make an inference. You can make a real inference on this. I don't think this judge. I just don't think it's there. But the judge essentially is saying, because he was it's not. The judge is saying you can make an inference, and the inference isn't that he's his attorney, so everything he said we can attribute it to Johnny. Her ruling is a little bit more narrow, is that he said these things in the course of his duties, but can you make an inference that he was saying this on behalf of Johnny Depp? And as evidence, she brought up a couple of things. The fact that Johnny was in the room one time when he did make the statements to the Daily Mail, right? Johnny was in the room. Is he making, was he working at that particular time? I'm assuming he's working for Johnny. Did he make the statements? He made the statements, not Johnny. Were those statements made on behalf of Johnny? Well, if he's in the room and they're working, yeah, right? You can infer that he made those statements. Now, if the statements are false, that's a whole nother issue, right? That's an issue that the jury's got to decide. So that's not what she's looking at, right? I believe those statements, Johnny, I think the statements that Amber made everything up, I think those are true statements. But that is an issue the jury has to decide. The issue here was, can a reasonable jury make an inference that Johnny's attorney made those statements on behalf of Johnny? And if you're saying that he's sitting in the room, right? He's sitting in a room with his attorney, and the attorney's making those statements. I think the judge is right. You can make that inference. But will the jury make that inference? I just don't know. Let me get these other questions out while they're still talking. Does the judge's ruling on not dismissing the counterclaim hurt JD's chances of winning? No, it just well, I think it if that counterclaim was dismissed, then it makes it easier, right? Because now you don't have to worry about her winning. But now with the counterclaims going to the jury, now you still have to use some of your time to kind of knock down those counterclaims, right? So I think that reevaluates your time remaining, because if the counterclaims go away, then you really can just don't even have to worry about them. But now, since the counterclaims are still there, it's great because I don't think they put on a lot of great evidence for the counterclaims, but I think it's hard because now Johnny Depp's team has to kind of throw some shade at the counterclaims while still doing a good rebuttal case. So it hurts it in the sense of, I think it hurts the process a little bit more. Can anyone who loses now can make an appeal? Yes. If you lose, I'm assuming I would appeal. Either side loses, they can appeal. Whether they appeal to be successful or not, and whether there'll be an issue of law, that's always a good question. But yeah, they can appeal, because the judges get it wrong all the time, right? Judges get it wrong all the time. There's so many cases where you'll read it and the Court of Appeal says this should have been dismissed at a motion to strike. Judge should have done this. Right? As a matter of law, the judge got it wrong. That's what happens on appeal. So the trial judge, don't forget, the trial judge is kind of working in the moment right now. So they are going to get things wrong. And that's why you appeal, because the trial judge gets it wrong. Oh, there's Nick. Okay, I got another guest, but he seemed to step away. So when he comes back, I'll put him on screen. Next question. Brawley says, question. I understand that Nate the lawyer, but was that even in evidence? Hence my question. That's the problem. I've watched the trial and I don't remember that being in evidence. The fact that they were in the room together, because I remember the attorney, but maybe that was, maybe she got that from somewhere. Just so everybody knows, it's actually unethical for a judge to bring in outside information to the court, right? The judge is duty bound to only look at stuff that has been shown to her in court. No facts outside. If that happens, she's supposed to actually recuse herself from the case. So she's under the same issues as the jury. She cannot look at outside evidence and then make this claim make that claim or use that in any ruling. That's essentially unethical. So no, I don't think I think that this had to be in something where the judge said, hey, this fact that is in some brief or has been testified to is in evidence, and the jury can make a ruling based on what's in evidence. Great question now, but it's, she's getting from somewhere. Let me bring in my friend Nick. Nick, what's going on, brother?
Hello, good sir. How are you?
I'm doing well.
Good.
What you've been watching the trial? What do you think?
It's crazy. It's absolutely crazy. It's been great to watch because you get to see so many different legal styles and how they approach things. But it's wow. I mean, I think people are going to be talking about this, years from now. Still, I think that this is assuming it goes Johnny Depp's. You know what? I think Depp has won no matter what at this point. There's a PR campaign separately, and he's won on that no matter what. And I will bet you that's more important to him. I think he's financially is in trouble. A win would help there. I think a win would help on so many other levels, and I think he good for him if he gets it. But he's won the PR campaign, right? So, and I think that's probably maybe more important to him. But who knows?
Yeah, I think the PR campaign is monstrous. I think the PR campaign is monstrous because that's essentially getting his career back. But we're at this point where I think no matter what happens, it's going to come down to this. This is a he said, she said case. Do you believe Amber Heard or do you believe Johnny Depp? And as of right now, let me introduce the crowd to you. This is my friend Nick. He's from a channel called In Time. I'm actually putting it in the description right now. If you guys want to join my friend Nick, he talks about essentially everything. You do breaking news. Nick, introduce your channel.
In time, we do news, politics, culture. We talk about law. We had on this lawyer, this Brody guy, a couple times. A little sketchy, but a lot of fun to have on. But we do cover breaking news. So if something big is happening live, we're often live. Every now and then we call up Nate, but sometimes he's live with it too. And then we talk about the Alito decision being leaked is one that we've been talking a lot about. We cover the Ukraine war as well, just because that's a big event that's influencing our culture here in the United States and across the world. And those are the kinds of things we talk about. We do interviews. We bring on experts. We've had on Commander Lance McMillan staged the invasion of Iraq for CENTCOM for the Fifth Fleet out of CENTCOM. We discuss what's going on there, and that's it. So a little overlap with Nate, some of the same similar things. But if you're interested in what's going on in the world and getting sort of the news in context, and also one of the other things that we do, and that's why I watch Nate's channel a lot, is because when talking about the soccer, the women's soccer, Kyle Rittenhouse, a few other things where the mainstream media really doesn't seem to get it right, we like to get a different take on it, and Nate's good at that, so that's we follow in.
Oh no, I appreciate it, and this case is all about, again, the pop culture narratives around this case. You can't. I don't think can be avoided, right? This is a Me Too case. This is the Me Too. This is I think, and I'm calling this the reverse Me Too case, right. in which you have a man who's been accused of some horrific things, was canceled, and now has come back and said she canceled me with a fake Me Too story, and it's defamatory. And I think that this is essentially, we're getting to the whole, when people just make wild allegations and people are canceled for them, this is the result, right? That's defamatory, and it's as clear as day if those statements are false. And I think this is the rubber that's meeting the road in this case. Can you just cancel people on allegations, and what happens if those allegations turn out to be false? Who should pay? And that's what we got here. Joseph Ross, thank you for the $20 super sticker. I really, really appreciate it. Let me take down some of these super chats while they're still because they're trying to bench you.
Oh yeah.
I'm coming back. Please go over legal agency, reasonable inference, and actual malice for the fans. Thanks for your effort. Emotion has to be removed from the analysis. Yes, discount Kitty. So I went over the legal agency, but legal agency is essentially if I'm employing you and as whatever, I'm employing you as whatever, and in that employment, I tell you to make a statement, and you make the statement on my behalf. You're my agent,
right.
and that's
Are we ready for the jury then?
That's for me. So
okay.
And actual malice is you made the statements and you knew they were false. That's essentially what it is. But thanks you, and you're right. I mean, we'd have to look at this without the motion. I think the judge made the right ruling. Thank you, discounted Christy. Discordant Christy. Thank you. Dan the hippie says, what witness do you think Team Johnny will bring in after Amber's team runs out of time? I would bring in Johnny Depp. That's what I would bring in Johnny Depp. If Amber team runs out of time, I bring in Johnny Depp and we end the trial with him, given his narrative. Jury already loves him. He gets free time to just go up there and speak his mind. I would end on Johnny Depp if I was running it. And I would be trying to run out their time to get to that. And if I can't get him on without being crossed, then I end on a good witness that is just going to make everything look so rosy for me. But right now, it's not about for Amber's team. It's about time. They have to be extremely.
Good morning, ladies and gentlemen. I apologize. We have a few housekeeping matters to take care of. Thank you.
What they do.
Have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
So if everybody knows, so now that Amber's
Your Honor, just to clarify, this is by deposition, so we may need that.
Okay, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
So just so we understand what's going on, they are now going to rebut things that were said by Amber Heard's team.
So I had a question because you had mentioned about the Me Too movement, and I think there's been, it's always it's hard getting the pulse of people when it comes to this. But we've seen also you had said whether this is a Me Too or the counter to Me Too. What happens? We've heard women say sometimes that they actually hate the false claims more than the men because it means women aren't believed in the future. What's going to happen to Amber Heard if he's found if they rule for Johnny? Is there a backlash against Amber Heard saying you've essentially destroyed the Me Too movement? What do you think happens there? Answer that later.
Warner Brothers Entertainment.
Let's hear the deputy answer right after this.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
Yes, this is going against Depp's time.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform an Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say.
Well,
so, and from there, beyond normal development, the role the character's involvement in the story was sort of what it was from the beginning.
Was her role ever reduced for any reason?
No, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was
So this is them destroying her
compensation for
counterclaim.
Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
If you don't want Depp to come on with unlimited time, do you think they just let this slide and take the hit? And
Was there any delay in Warner
Yeah, there's
Brothers
no-
exercising the option to
after
cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
So they were
Did
talking about
Warner
recasting
Brothers,
her before this. Wow.
Take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
That destroys all her damages for the counterclaim, because her
What
counterclaim
role, if any,
is destroyed.
did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
Wow, yesterday we heard about they having such great chemistry. Now Warner Brothers say the chemistry
At
wasn't
any
that
point
great.
in time,
We talked about
was
recasting
Warner
right after
Brothers
the movie.
considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
So everything they said yesterday was all debunked right now by Warner
At
Brothers.
any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been at the same time that I was having those conversations with Peter Safran.
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
Part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. I cannot tell you. Probably in 2018, latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script.
All right. What, if anything, did Rob Cowan say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, it looked like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Fabricated.
Well, those are just it's editorial. And a good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
And what do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is on any production. You're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works. And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make the most successful production.
Absolutely.
Tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2. Is that correct? And Aquaman, the first one, correct?
That's correct.
All right. And James, is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. You see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying,
That'd be a test screening. So during our post-production of the movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
and they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any
she was told they didn't have
document
chemistry
that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Colburn next, but I know we have a preliminary matter that we need to deal with briefly, if we may approach. Sure.
All right. So what did we just hear, and why is it important, right? So this is why you come here to watch it with us. Okay. So Amber's whole counterclaim was dependent upon she had Aquaman 2 locked up, and Aquaman 2 is all messed up because of the statements that Johnny's attorneys made about it, the alleged defamatory statements. And one of the big issues, as we heard yesterday, when her PR person was talking, was like, oh, Amber and they had great chemistry. They did the screen test. Chemistry. Their chemistry was amazing. And we knew that she was going to do 5 more Aquaman movies, right? Because she was just so wonderful. But today, we get the head of the studio, and he says, after the first movie, we said, there's a chemistry problem here. We did way too much in the background to fix it, right? It took us hours to fix this chemistry problem. Usually you could put 2 people on the stage, you got chemistry. With them, he said we had to fabricate it. We had to make it up, right? The chemistry is something we got to make this crap up, right? Chemistry was an issue. And the key points that I think people have to really understand is when it became an issue. It didn't become an issue after the statements. It was an issue after Aquaman 1 landed, right? That was the issue. Here's Aquaman 1. We got a chemistry problem, right? You know, the editors are probably back there like, yo, we got to do the movie magic. We got to fabricate all this stuff. So that hurts her claim that she was going to be in the rest of these Aquaman movies, that this was her big break, and that Mira was the number one, was almost a co-lead with Aquaman. The second piece of information I think is vital to their claim is simple. And that is the Aquaman 2, she wasn't going to be co-lead with Momoa. She was a side character, and it was a buddy comedy with another guy. So even in Aquaman 2, her role was reduced because the movie was going in a whole nother direction. So it seems like her role was being reduced, not because of any statements. And this guy made it very clear. There was no statement that was made by Johnny Depp and his attorney, right? They asked, did these affect you? He said, no, we didn't care about that. Chemistry was an issue, and this was an issue. She was great on set, but we were doing this. And then the last part is, would she have made more money on the next movies? And he said, absolutely not. She's a B actress. This is her big break. She's getting the same amount of money, right? We're not going to renegotiate. We can renegotiate with Jason Momoa, right? Because he's a monster star, right? There is no Aquaman without Jason Momoa. He is Aquaman, right? There's no movie without Jason Momoa. He can renegotiate. Amber Heard, we can recast. That is what the jury's going away with. They were talking about recasting her before they re-signed her, before anything. So that's where we're at right now. Nick, I know I put a whole mouthful out there. What's your impressions?
My biggest question is, if they knew this was there, this was a deposition. They clearly attended the deposition. They're so low on time now, and they have to try to keep time so that what you talked about, sort of the ideal scenario for Johnny Depp, where they can just put Depp on and just basically let him talk. He can do his own closing practically, on there. They have to try to avoid that. The only way they can avoid that is to save time. And they had to know that this was there. So either they've got something else up their sleeve that we haven't thought of, or I'm not sure why they have to know what was in the deposition. But no, I think the strategy plays a lot into, they have to think strategically now a lot more. You always have to plan these things. You always have to say, how are we going to pace, and how are we going to get which witnesses are going to have the most impact at what point. But they don't, the momentum's against them. They're almost out of time. They don't have the ability to mess around with stuff like this anymore if they want to win. I don't know what the counterclaim is secondary. I don't know what they're doing.
So yes, the counterclaim should be secondary. But so this first witness, so everyone understands what this first witness was designed to do. This first witness was to attack Amber Heard's counterclaim. This wasn't to bolster Johnny Depp's original case. It's to kill her counterclaim. So her counterclaim is, Warner Brothers, and I was going to be Aquawoman. Warner Brothers is like, you barely were going to continue to be Mira, right? There were doubts if you were going to continue on, right? Aquaman 2 might have been your last Aquaman, right? And you weren't getting paid more. So this wasn't like a Zendaya. This wasn't Jason Momoa. This wasn't Wonder Woman, because Wonder Woman can't be replaced in a Wonder Woman movie, right? Wonder Woman can't be replaced, right? It's Wonder Woman, for instance, right? Gal Gadot isn't going to be replaced. Aquaman isn't going to be replaced. They can't recast, but they could recast Mira. And the fact that I think that they even thought about recasting Mira, I think was I think was damning. Was really damning. So, first witness, what do you think? How do you think the defense is going to, how do you think Amber's team is going to combat this? Because essentially they're saying that she didn't really lose anything based on those statements. Do you think this hurts her claim, her defamation claim? Because her defamation claim is she lost Aquaman, her role was reduced because of these statements. What do you think? What do you think now?
I think it hurts the whole case, because I think the problem is, I think she had a lot of problems when she was testifying, and I think the jury will look past that and say, well, it's kind of tough and so on and so forth, if that's just the only problem. But it's just sort of time and time again where a witness comes up and it turns out that what Amber Heard's been claiming in one way or another doesn't mesh with what we're being told, and this is just another example of that. So I think this actually digs the hole on the main case. Even though, this is really a separate issue. It's for the counterclaim, but there's no way the jury's going to separate. They're just going to say, hey, look, and then just look at this pattern that we've been seeing time and time again. I think her defense would have been better if they had not gone down this avenue. I think this hurts them. The only chance they've got is, everybody, there's a million things going on at all times in everything. And especially when you're making a movie, somebody somewhere in some position of power probably thought they had great chemistry. So if they've already found that guy and they've already had a deposition and they know what he's going to say, maybe throw him up. But this is the head of the studio. I don't know how you combat this. Now, it may be at one point he was thinking this, and then he was thinking something else, and he changed his mind. So do they have something that they knew this deposition was there? They
questioned him. They knew it was there. They were questioning. Yeah. But the thing is that it also, and this is just my thinking, it also showed that Amber Heard was lying a little bit, right? She said, yes, I didn't know any of this stuff. And the guy's like, no, we told them straight up, right? That there wasn't a chemistry issue, right? We worked too hard on the back end for the chemistry issue. And she was, but she and on her testimony is like, oh no, we had great chemistry yesterday. Oh no, they had great chemistry. They did a chemistry test. Now we know those were all lies, right? Those were all absolute lies because the studio head just said right after it happened, right after we had to fabricate the chemistry, we reached out to them and was like, yo, we got an issue here with chemistry and we may be able to overcome it, but we may be even thinking about recasting here. That I think, damn, because again, it's not the linchpin, but it shows that she's lying about everything, right? She could have been honest and said, yeah, they said we had a chemistry issue and they were working around it, but que sera. But she went on and said, no, there was no chemistry issue. She cashed those wolf tickets, and now it's there's no money in the bank. And I think this witness destroyed that. Let me read the super chat. JD's lawyer spoke at the UK publication. To a UK publication.
Ladies and
ought to
gentlemen,
apply Virginia law.
I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss the case and do not talk to anybody, okay?
Is a primary source
not
of
do
the
any outside
suit,
research.
the
Sorry, that was
Washington
the
Post
same thing.
article. What decides the jurisdiction for everything? If the statements were made,
Take a break.
it's interesting. JD's lawyer spoke to the UK publication, but I think they were talking about because the statements were being made everywhere. Like he didn't just speak to UK publication.
If the doctor testifies, then is that WebEx? Okay, so I'll get that set up too while we take the break as well. All right.
Doctor
All right,
testifying.
we'll go ahead and take a break. Let's make it 10:50 to give him time to look at everything, okay?
15 minutes are coming back at 10:50. All right. Well, the judge is out. I'm gonna pull this off the screen now. So let me finish reading the super chat. Okay, so just so you guys can understand. What they're saying is that there's an inference that could be made. Thank you again for the generous super chat. There's an inference that can be made. The inference is he did that in the UK. We can't sue him for that stuff in the UK, but we can infer if he's sitting there in the UK with these other let me move that. If he's sitting there in the UK with these other witnesses, let me stop. Let me turn this off in the background. Sorry. So the inference is if he's making these statements in the UK, right, with this attorney, and then he comes to the United States and he's not in the room, but those same statements are made by the attorney all over the place. The jury can infer that the statements were from Depp because it was, because of that evidence, right? He was in the room at the time the attorney was making statements. It seems like he was making them on his behalf, and then he comes to the United States and makes them all again. So that's kind of with it. That's the line of reasoning I think they're using for the UK statement. So she's saying you can infer he's making those statements on his behalf because in this instance, he obviously was, and they can infer that the other times he made the statements, he was also doing it on his behalf. So that's how the UK stuff gets in. I know it's a little confusing, but essentially that's what we're looking at right now. So now I'm assuming they're going to have a doctor come on and talk about the Johnny Depp's hand. So the first witness was going against her counterclaim. What do you think the chances of her winning on her counterclaim are?
That's hard to say. I know so much less about the counterclaim, but I have to believe they're reasonably small by this point. You use a word a lot that there's the vernacular that's used in the legal system that annoys. You keep talking about credibility. Well, why aren't you talking about truth? Well, you're not talking about truth because that's not for us to decide. That's for the jury to decide. So when you talk about credibility, this has really damaged her credibility. And there are a lot of things that maybe she said on the stand that were completely true. And, people aren't going to believe her as much anymore. And she's already been busted in a couple of lies. But this every time this happens, it's just sort of like it's harder and harder to believe anything she says on on her defense or on the counterclaim. I from the little I've seen, I think her counterclaim is going to have a very hard time going forward. I think the jury isn't above wrath and revenge. They've been sitting here listening to this stuff, and at some point it's entirely possible that they're going to say, you know what, Amber Heard put everybody in this courtroom. They're the reason we have to come in here. And all she ever had to do was tell the truth from the beginning, have as clean a separation as you could, and just leave it at that. And here we are. And then just hand her ass to her on absolutely everything. That's a distinct possibility. And so I think the counterclaim is, I think it's a really bad idea at this point. I think they should have just defense. They got enough problems on their own defense. Leave it at that. Don't bring up any more witnesses than they need to, and just try to get out of this unscathed. I think it's a bad idea. I think she's going to lose it.
Yeah, it's the problem is, and just so everybody understands too, before we get into some of these questions, this case, I don't care what anybody else is telling you. I don't care what anybody else is telling you anywhere around the world. This is a he said, she said case, right? She says he did this, he says he didn't, and only thing we have to do, like Nick was saying, is about credibility. Who do we believe? Who can we believe, right? And I think at this point, it's hard to believe someone who's been caught in as many lies as Amber Heard has been caught in, right? It's not that we don't believe women. It's not any of that stuff. It's just that and the one I think that makes it obvious that she has an ability not to be truthful is the whole charity thing, right? That's a lie. It's what I like to call an unforced error in law. And what I mean by that is, if she says, I pledged it, but I hadn't donated as of yet, and I never got around to it, blah, blah, blah. But yeah, I told people I donated it because that was my intention, but I didn't do it. So yes, I'm sorry. And then when it came to it, the trial happened. And at that point, I couldn't donate it. You know, I couldn't even go into payment plans because I needed it to defend myself. That is reasonable. That's understandable. Hey, you meant to give it. You told everybody, but then search circumstances changed. Yes, it took a year, but who really knew? So that type of thing, right? Those are stories that even if you may not agree with the timing and everything, but it's something that you can hang your hat on and say, okay, I can believe that. But instead of saying that, she said, I donated the money, right? And donating and what is it? She said donating and pledging.
Pledge. Yeah. Pledge.
Are identical. Now, everybody who has a job, right? Anybody who has a job knows the difference between donating and pledging, right? Because that's the difference between somebody giving you something and you say you're going to give somebody something, right? Just imagine your boss says, we're going to, we're going to do, we pledge to pay you this. We're pledging to pay you.
It's like telling that to the IRS, right?
Yeah.
I mean, like
we pledge
you
to give you your taxes.
Yeah.
I pledge I'll pay it, right? And then when they come back and where's the money? No, I pledged it, so that means I paid it. No, we don't got any money. I pledged it. I pledged it. So that it, and the problem is when you lie about little stupid things like that, then when you tell me I was beat up and I was the only one there, and you have to rely on my good word, good name alone. You just told me a lot that you donated money that we can obviously confirm you didn't donate. Now I got a situation where I can't confirm any of this stuff happens. Only thing I can confirm is that you're telling me this. What other evidence do you have to back it up? Not that I don't believe you. It's just that you've been caught exaggerating before. How do I know you're not exaggerating now? I just need more. Then when you got the pictures of her being bruised, right? Picture of her. I was beat up he dragged me around the floor on glass, punched me in the face with a cast multiple times, beat me up, and here I'm on the next day. Looks like not one injury, right? Here's a picture of me the next day with no injury. You just said you went through a violent assault. Next day, no injuries? Really? So as a jury, you have to just kind of start looking at, I can't believe that story. And to what point do you believe nothing? And I think that's the problem with Amber Heard's team now. Has she gotten to the point? Because with all witnesses, you'll say people are being deceptive and people aren't telling the truth. That's going to happen with every witness, right? Who do you believe about widow? But when you got a he said, she said case like this, has it gotten to the point where Amber Heard, I'm asking the chat this too, and I'm asking my guests, has Amber Heard gotten to the point where we can't believe anything she says? Carte blanche. Has she gotten to that point, Nick?
Yes, I think she has. I think she probably did a while ago. And it's always hard. You think you know what the jury's doing, and sometimes you can predict it reasonably accurately, but you never know what's going to happen when it goes to you just don't know. But I think she has, and I think it's the thing I'd like to have done if I was. It's an aggressive move, and it's one that looks great on television. Isn't necessarily productive, but it's like, okay, so you pledged the money, but that doesn't mean that it actually happened. It just means that there was a promise, right? Well, you use that word differently than the lawyers, than every other English speaking, because she kept saying that was her defense too. That's not how I use the word. So how do you use the word hit Does that just mean he looked at you funny? But it's, I mean, it's just, you know, it's she can use that defense on it. So yeah, I think she's, and that was one. She should have just trusted her lawyer. Let her lawyer clean up the damage. There'd be some damage, but let the lawyer clean it up on recross, or yeah, it would have been recross. You know, don't. And it was a terrible. I think her credibility is, and especially because in some of her testimony, she did seem credible. But if in the testimony where she seemed credible, especially like, no, we did have chemistry, we did, and then now it's been obliterated, it's sort of like, okay, it doesn't matter if she looks like she's lying or she's telling the truth. None of us can tell. So I think, my view is she's buried on this. But again, you don't know until the jury comes back. But that's my view. I don't know.
Yeah, no, I'm agreeing with you. It's the problem here, which has always been the problem with this case, is that if we were just with the whole narrative, because there's a narrative of believe all women, but there's also a narrative of believe victims, and then there's a narrative of kind of like this, the Me Too narrative, and what happens is, and I think we should all say, Amber Heard took advantage of the Me Too narrative in a sense of the Believe All Women campaign. And you heard that even from that recording, right? The recording, Nick, I don't know if you heard the recording, but there's a recording in which Amber Heard says, Johnny,
I know which one, yeah.
I'm a woman. Nobody's going to believe that I'm beating you up. Nobody's going to believe that I'm abusing you. No, you're a man. I'm a woman. Go tell the world, tell the jury, tell the judge. Do you really think anybody's going to believe you? But she knew that was, and she can say that confidently because she knows the world that we're coming. We're in the Me Too era, and she's going to be presumptively believed, right? Presumptively believed because of what's been happening. And I think that's what happened in this case. And now Johnny's put on all this evidence to show that what she's been saying is absolutely false. And then she confirmed that it's absolutely false, right? And now, so at this point, what does Johnny Depp need to do to overcome? I think, like Nick has just said, he's already won in the court of public opinion because I think her lies have been exposed. But now to win this case, yeah, we'll see. Let me knock down some of these super chats too. Go ahead.
Well, I got a question for you. I think I am, as Dr. Reverend Christopher Mowdy would say, made of questions. I think there's good questions about, does Me Too sort of apply to men, or I mean I think the purpose and intent of protecting victims does, but men there's a disparity of power that it's sort of like the Black Lives Matter. It's like when you counter with all lives matter, it's like, well, you've missed the point. But there is a question that people have asked about and people are talking about, and I think this is desperately unfair, but I think this needs to be, there has always been a difference in what men can get away with and what women can get away with. And in some cases, it's better or worse, and in some cases, it's not. It's just different things. When Ingrid Bergman had an affair, it ended her career. Men could have 30 affairs, get busted, and they are still bankable stars. Ingrid Bergman does it, boom, done. Gone. Her career is over. Now, people have said that this is going to end Amber Heard's career. I don't think so. I actually disagree, because I think that there is a double standard, and I think we have different expectations. If it had been a guy, his career would be done, over forever. I think she's going to get 2 years in the penalty box, and then I think she comes back. And it's because it's just grossly unfair. It's because, men can get away with some things that women can't. Women can get away with some things men can't. I think she's going to be forgiven by Hollywood. I don't think this ends her career. I could be way wrong, and I'm not saying it's fair. I'm just saying I think that's what's going to happen. I don't think this is. I think she can come back. I think she could have come back from this much better than Johnny could have, and it's part of that difference in how we treat men and women.
Woof, that's interesting. I don't know, because the difference is, if I would say this, I would think she could come back if it was kind of like nebulous, like, could it happen? Could it not have happened? Is it a push? Fine. But I think there's just so much evidence that she exaggerates and she lies that it's hard to come back from that, because every movie that she's going to be associated, every project, there are going to be people out there like, this is a liar. How many people are going to boycott Aquaman 2 if she's in that movie? That's hurting your bottom line.
Well, no, the bottom line is, and I hate to say this, the bottom line is she pretty? Because that's one of the things. Obviously, they want someone who can act, but they talk about cleaning it up too. Hollywood is about the glitz, the glam, and if she can fit that, they can forgive so much. And
well, Well, you know what? We will find out. I think you're right.
will,
Where,
yeah.
there are going to be people who want to allow her back in, but I think at the end of the day, it's all about dollars and cents. Let me read these super chats out because we're about to get back. The child's about to come back.
Yeah.
Secret recording made by Amber Heard in California. Yet she's no criminal charges. There is a two-party consent state. Yes, but remember there has to be the local authorities. The district attorney, whatever, has to, there has to be charges filed, that type of thing. So I'm not sure if anybody's made a criminal complaint, but if there hasn't been, that's the district attorney in California. And let's not forget too, the LA district attorney says that they're not doing anything, they're allowing people to walk out of prison for armed robbery. So I think perjury is not really high on their on their list. But yeah, it would be a violation, and maybe she could be prosecuted, but I don't think they're taking that case. Legal Bytes stated both sides stipulated to this, but how does this cover the state law violation? It doesn't cover the state law violation in California, but it does cover bringing in that testimony into a Virginia court. That does, because Virginia, it's not illegal in Virginia. It was illegal in California. So they're saying, hey, we both stipulate to letting this be played. You're in Virginia, different rules, different state. In California, it may have been a problem, but I think in Virginia it's not. Amber Heard is new breed, assaulting gold digger. Lethal Latin, you're funny. Amber Heard just wrongly feels entitled to try and bury Johnny. You want to sue me? I'll sue you double. Her case looks like one giant projection gaslight. I agree 110%. Lethal Latin says, what's it? Kirsty the Crusty chat knows what's up. Christy the Crusty chat knows what's up. Oh no, you got chat beef now. And this one, Mary Kelly says, pretty blondes are a dime a dozen in Hollywood. Yeah, pretty blonde, 6 foot blonde. That's true. She's old by actress' standards now. So you're essentially saying we got an old actress. We have an old actress who has all this baggage. I'm going to tell you, Nick, I think it's just going to be difficult, bro, because if we just take this for what it is, we just have really a lot of, there's just too many factors. I just going to say there's just too many factors.
Yeah. Well, that's a good point. I mean, if she takes a 2-year timeout, that affects women more than men. But look, Roman Polanski came back. I mean, this is an industry that's very forgiving of certain kinds of things, and there are different kinds of things for the men and the women. They can each get away with murder in certain areas, and I think she's got a shot at coming back. But yeah, I think she's got a bigger shot. I don't think this is necessarily a career breaker, and I think she probably could come back. Is she going to? That's a good question. I think that's fair if she takes a 2-year timeout. But I don't think it has to end her career in the same way.
I think she's being canceled. I think she's going to be canceled. I think if she loses, she's canceled. I think
she's canceled, it's going to be by women, not by men. I think men would, believe it or not, would look the other way more.
But I think that's who's doing the cancellation. Most of the time, it's women. We got 30 seconds before trial comes back on. Not that they would, but do you think DC? I'm not sure what DC is. Do you think DC would have a case for suing Amber for defamation for what she said? Love your work. Do you think DC? Who's DC? Oh, DC, the company. I don't think so. I don't think so, because she's saying that she believed that they were going to rehire her. So I don't think she's going to have any issues with that. But I don't think DC has any issues with that, because again, she has an option contract. So they're unless she's. What did she say about DC? I don't think anything she said about DC hurts their reputation, right? I just don't see it. Maybe you can elaborate. Don't have to shoot another super chat, but I just don't see any cause of action for defamation against DC for Amber Heard, or from Amber Heard to DC. I just don't see it. Let me put this back up on the screen. Here we are. Let's zoom in. So the judge said 10:50. We're almost back. Let me make the screen so we can see.
Every time I see the Sic Semper Tyrannis, it's a little. It's just you see the stabbing, and I'm just like, okay, that's still a little shocking every time I see it.
Here it is. so we talked about this. Yeah, I don't know. That one's hard. If Umar, if you see the follow up from Ban the Hippies, let me know, because I don't think they have a cause of action. Ramak Baladsky had talent, and that's, I think Mary's right about that one. IT Ninja says all she is pretty. Depp got her those parts. That's true. She cannot act. She is DOA. She will resurface only for OnlyFans. IT Ninja thinks she's gone. Question. Kia says, how do you cancel someone who was never famous? She was an Aquaman. You know, I understand, Kia. I understand people not hating her, but she was an Aquaman. She was in $1 billion film, and she was she wasn't the co-lead, but she was there. So, you know, she was famous. People knew who she was. People know who she is now for sure. So I think canceling her means she won't be getting me more roles in Hollywood. And she's a great villain, intriguing for the right role. I think this is true. But the problem, I think people don't understand the problem. And I'll put, matter of fact, I'm going to put this poll in the chat. Would you go watch a movie that Amber Heard is in? That they build it. Amber Heard's in this movie. I think most of the people in this chat are going to say no. And I think most people are reasonable in that assumption, saying, hey, I just don't believe her. So if that's the case, then as a movie producer, why the hell would I,
That's true.
with all these other actresses out there with no problems, right? Hell, I can get a body double who looks like Amber Heard, right? I'm picking blondes. You can pick one up off the street, right?
But okay, so
just as pretty as Amber. It's not like she's the only pretty face in Hollywood. So it's it's like, what do I go through the trouble of bringing on Amber so people are boycotted because of her, or do I bring on Lily Jean and have her do it and nobody knows who she is and I don't have that problem?
2 years ago, COVID was not a thing. Now COVID's a thing. The attention span of the public, especially when it comes to Hollywood, that's why I said 2-year timeout. She gets a 2-year timeout, and then everybody forgets. And then Amber Heard's in a movie, and they're like, Amber Heard, that name sounds familiar. But the amount that can change in 2 years, and the amount of forgiveness, especially if in some other way she's bankable. I think you've got a great point about a producer. They're gonna, but I still think time heals wounds like this, and especially in Hollywood, very rapidly. Give it 2 years, I think she's bankable again. What's going to happen, I don't know, but I don't think you can say she's out. She's got problems. I don't think it knocks her out, but that's my view. Hit the super chat, but that's my view.
Yeah, but I can see it going both ways, because I can see where you're right. 2 years later, people forget about this. Times have changed. She gets a good role. She may get a minor B role. People like her, and then you start the whole strategy again. It's possible, but I just think it's unlikely. For the next 2-3 years, I think she's done. This woman's. I think
that's true. Yeah,
the woman's
over for a couple of years.
Yeah, I think coming out of this trial, she's done. The woman standing above the man is a pose that Amber wished she could do to Johnny. Which woman? The woman standing above the man. Oh, and the
oh, geez, and the six emperor.
Yeah,
damn.
Yeah,
she's been trying. She's been Well, that was clever.
Forgiveness requires you admit what you did, but listen. Have you guys read like some of the articles that have gone on? There's that guys still eat Chick-fil-A. JD's fans can't look away. That's true. I would think gays. So gays still eat Chick-fil-A.
Yeah.
Oh, because they have that policy. Yeah. But that's because Chick-fil-A is so good, right? Chick-fil-A is saying, yo, we got the best chicken sandwiches. We don't care what you think about our policies, whatever. We got the best chicken sandwiches. Buy them if you want. And people still buy them, right? Because they like the chicken sandwiches. It says, I know DC would never actually sue her personally. I just wanted to know if everything she said about, let me turn on the volume here so we can hear what they're saying. Doop.
Sir, can you hear me?
Now we can hear you.
Yes. Can you hear me?
Yes. Can you count to 5 for me?
1, 2, 3, 4, 5.
All right. I'm just trying to get you on the big screen. We're waiting for the jury. Just give us a minute, okay, sir?
Thank you.
So this is their rebuttal witness.
How much time do they have left?
Johnny Seam had 16 hours, or 15 hours, and they only had 16 hours, essentially 16 hours, and the other side had 4. But I think these depositions are killing their time now. So Ricada just let me see. LOL, Ricada just photoshopped dimensions into the emblem standing over Spiegel.
Thank you. You can be seated. All right, your next witness.
We called Dr. Colbert.
All right, sir, if you could raise your right hand.
Is Amber Heard
Do
even
you swear affirm to tell the
collectible?
truth under penalty of law?
She was yes.
Yes.
I don't think so.
Your Honor, I would just object that Dr. Culver appears to have a stack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just testify from your memory. Okay, sir? Thank you.
Thank you, Your Honor.
All right, your question.
Good catch.
Good morning, Dr. Colbert.
No.
Morning.
Could you please state your full name for the record?
David Allen Colbert.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years.
Where
So
do you currently work?
this is their expert to counter
At
Amber's
Cedar
expert.
Sinai Medical Center
How long have you worked there?
for the past 26 years.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
When did Mr. Depp become your patient?
Sometime in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
Debriding the devitalized tissue, putting a hypothenar skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery? I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
It was injured and had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
It was a plaster splint.
And can you please describe to the jury what a plaster splint would look like?
So it's like a cast, but you don't want to put everything circumferential on it because of swelling after surgery. So I believe in Mr. Depp's case, it was like the 2 fingers. I think the 3rd finger was the one that was operated on. So these 2 fingers, the 3rd and 4th finger together. And it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his 3rd and 4th fingers.
Thanks, Owen. I really appreciate that, bro.
because
Thank
of
you
the
so much.
bulkiness of the splint. Typically,
Thanks again.
post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
So you can't grab anybody with that.
Oh, it'd be painful, I would imagine, as well.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office
Yeah. I've
How
had
long
that
did
done
you
too.
ultimately treat Mr. Depp for his hand injury?
for several months.
And why was that?
It was a bad injury. It required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same, around 2015.
Thank you, Dr. Colbert.
All right, cross-examination.
So let's see if they're going to get in and get out.
Good morning, Dr. Culver. So you said that this plaster splint was put on after surgery on March 20th.
I think we lost audio.
Yeah, yeah.
Let me see if I can get it back.
Obviously, you're using the same producer we use. Oh,
No?
come on, that was funny.
I think
that
they
was
lost
funny.
audio,
Come
yeah.
on.
It was.
Yeah.
No, the stream lost audio.
Yeah, yeah.
All right, so Law&Crime. I like people in the chat that read no sound, no sound. Look at the chat. It's muted. Audio. All right, let me see if I can find another stream while we're waiting.
So
they got 700,000 people sitting there watching.
Jesus.
Yeah.
So yeah, no, there's a couple of questions I've been thinking about, and yeah, so you got to read the super. I love it how I'm about to ask you a tough. Oh, yeah.
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
All right.
All right, here we go.
Permission to publish?
Yes, sir.
Dr. Culber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Ms. Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Overruled.
Yeah, he's a hand doctor.
I mean, he had his other hand available. So.
No further questions. Thank you.
All right, redirect.
So you see they're getting in and getting out. Getting in and getting out.
Dr. Culver, how many fingers were in the plaster portion of Mr. Depp's cast?
Three, at least two were. And the third one and the fourth one.
And why did you call
Law&Crime?
Because it's not fully, plaster doesn't go around the entire hand, because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential. So there's soft spots to it.
and where are those soft spots located again?
Usually we put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have damaged the cast.
And or his hand.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
I don't recall. That's nothing that comes to mind.
Could Mr. Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Kolber.
All right. Thank you, sir. That concludes your testimony. Thank you. All right. Your next witness.
Plaintiff calls Richard Marks, Your Honor.
All right. Mr. Marks.
Who is this?
Sorry, just a reminder that you're. Hold on. Hold on. Just give us a second over the TV. No, sir, you've already, just remind that you're still under oath. Okay, sir?
This is a straight recall. Amber is done until she admits she lied and asked for Depp to forgive her and do something to prove herself as genuine. Yes, Grammy, you're right. 110%. I think she's done. Thanks again, Owen. I appreciate it, bro. Nate, my man, I'm watching from the start since I turned up late to the stream. So even, thanks, man, for the great coverage. Thank you so much, bro. Thank you. And CB10 says, Nate, I went to Aquaman and had no clue it was her. Most people I know don't know
Yes, ma'am.
she
Thank
was
you, Your Honor.
she was her.
Welcome back, Mr. Marks.
Let me let Mr. Marks.
You've
know.
testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals every day for productions and for individuals. I'm in the trenches negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
Just throwing shade at their expert already.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yeah.
Yes.
Have you been asked to analyze that testimony and provide opinions in response?
Yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
That's exactly what I was saying.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yeah, they're both the slimy.
Yes, I heard that opinion.
I think they're all.
And are you
they're
also
both the
familiar
slimy.
with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Yes, you heard Warner
Absolutely
Brothers just say,
not.
Warner Brothers
Why
just
not,
said
sir?
they didn't do that.
Well, what we're dealing with in this case is a test option agreement. And that's an agreement, it's a multi-picture agreement, and it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9, and you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the Stars Born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary when she got the part was $450,000.
Yeah, Lethal Latin.
If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated normally. They are in some instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role.
Yeah. Jason Momoa.
Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them. And then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals. And by that, I mean that you assume success. The reason you go from the first Justice League movie where Ms. Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Ms. Arnold was referring to, a renegotiation, if you will, for the 3rd movie. Instead of doubling her salary, Ms. Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I've said, that would now be after a healthy first payday. It's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it.
Thanks for coming to remember. Yeah, that's
Miss Arnold, for
some
substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left, and you want that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take. And unfortunately, Ms. Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts.
We don't know their options.
We don't know anything except she's asking you just to believe her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks.
They're
Are
killing
you familiar
Amber
with her
for that.
testimony
Oh my
that
God.
Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with. And I think there is reasons to negotiate. They weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum. To assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character. And Ms. Arnold says that Ms. Heard's breakout moment, her Star is Born moment, is Christmas 2018. If that's true, and I don't think it's true, those moments don't normally happen to supporting cast, but if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in, to take advantage of this hot star and to sign them up. And we have from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Ms. Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the $1 million Ms. Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor.
She's freaking
He's
out
been
with this.
in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a comparable.
Unresponsive to.
All right, I'll sustain the objection. Next question.
Yeah,
Mr. Marks, we'll get to some of those issues in
all
a
out,
moment,
though.
but I want to take
Yeah,
you back for a second. I believe you testified a few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movie where Mira appears, that character. And they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
She is.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Shock.
Again, this is a business of personalities. We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't. What Ms. Arnold shows you is these non-comparable actors, they had endorsement deals, but she doesn't show you when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these deals, why wouldn't she? But for the statements that happened 16 months later, and I guess my primary question is what happened in the 16 months, even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an opinion.
What's your opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role, and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes, and it was $200,000 an episode. True. And Miss Arnold is
discounting that
from somewhere in a glib way, saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode. And again, in those 16 months, there were no offers for series at $1 million.
And the one she got was only 200,000 per
only
episode.
series is the 200,000. And if you look at her resume,
he's right. He's right.
The series that Miss Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Miss Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode. If you're to believe that, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes.
Yeah.
He was in, again, there's not a comparableness there.
That's true. Yeah. You're talking about an established actor with
We
many
spoke
episodes.
a few minutes ago about the test option agreement. What's the significance of the option part of that agreement?
They are destroying her case.
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not, they might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be, but it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed, you're hired to play the role. In an option agreement, once they exercise the option for that movie, it becomes a guaranteed contract.
So option contract is.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and
She's still going.
subsequently
She's still-
rehired?
I heard that testimony.
Is that consistent with your experience in the film industry in connection with these multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring. And in my experience, in almost 5 decades in the business,
she's working hard
doing
over
this
there.
type of work,
Like an Amber.
not
She's
talking
passing
about
notes like
it,
crazy.
not consulting. I mean, I have, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, it's not a contract till they option it, and they pick up their option, and at that point, it's guaranteed contract, and then different rules apply to it.
Makes sense.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath, basically saying that there was this discussion of chemistry. That
objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that it's hearsay like yesterday. I mean, it's hearsay.
It's an in-court statement.
Overruled objection. Go ahead.
It's an
Thank you.
in-court statement. It wasn't an out-of-court
Go ahead.
statement.
Sure.
It was made. It literally was made in court.
Overruled. You can continue, Mr. Rose.
I'm surprised to hear Mr. Hamada say that they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor. You're either going to exercise or not. And that was quite a bit of candor from someone at his level. And so, therefore, I take it at face value. I think he felt that he was under oath and he was telling the truth, but it wouldn't
Objection,
be.
Your Honor, is.
I'll sustain the objection.
Yeah, you can't talk about.
Mr. Marks, are there circumstances where a studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor, but not play them.
I will.
Pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we still have a right to recast and not make the movie. We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
I heard that.
And what's your opinion of those actors as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't comparable.
I believe same response, Your Honor, that it was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
But you can cross-examine overruled.
It's in court statement.
Overruled. You may continue, Mr. Rose.
Again, they are not comparable. Jason Momoa was Aquaman. Chris Pine was Captain
Kirk. Yeah, these are lead actors.
Gal Gadot was Wonder Woman.
Yeah.
Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Ana de Armas, when she was in a movie that they call, her breakout, it was as a nude poster. She's been an ensemble piece, Knives Out. These are not comparables. Now, Ms. Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career. But she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And she built like this house of cards on nothing. She showed us with her words, the beautiful clothing that the emperor was wearing. But we could see, if you know the business.
Objection, Your Honor.
That he wasn't.
Beyond the scope of the question.
All right. I'll sustain the objection. Next
I'll
question.
sustain that one.
You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to Mr. Momoa as an actor with equivalent franchise experience who was able to renegotiate his salary for significant increases in bonus?
Yeah, that was a mistake.
What's your response to that opinion?
It's not. That's
Again,
not accurate.
he didn't have comparable franchise experience to Miss Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable.
Right.
And you can say the words, but I saw nothing from Miss Arnold to back it up, something to build on, which if she was a negotiator in the trench, the studio negotiator would say, okay, so show us, where's the comps? Let's talk numbers, because ultimately that's where we have to get to, not just because you say it so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Well, first it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings.
Makes sense.
Precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings. And I didn't see any, Ms. Arnold talked about past earnings at all, except the earnings in this rarefied superhero 4-picture deal where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15 small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later. So I think the timing
that doesn't make sense.
Sure.
Yeah, see, the part that now I think Johnny's team is taking up a lot of time with this, but the key points here that he's trying to bring out is number one, Aquaman 2 comes out in December, right? 13 months later, the statements come out. Now, between Aquaman 1, I've said Aquaman coming out, the big break, and the defamatory statements, there's a time frame. And in that time frame, the Amber's expert said she should be getting $100 million per episode on a series. But did she? So they went back and she was doing a series called The Stand. Did she get $1 million, right? She just was in Aquaman. She's making all this money. Did she get it? No. She got $200,000 per episode. So they're saying what she's saying doesn't match what actually happened before the statements.
Mr. Marks, what's your overall assessment of Ms. Arnold's opinions in this case?
Yeah. My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something about our business, but not about negotiating deals. She may have gotten someone at the Endeavor office to breach confidentiality, but she never laid out the building blocks.
There's objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes deals.
Well, and you're worth what the market will bear. The market wasn't bearing it. She wasn't being hired at that amount. So,
yeah, this guy's got a. I think he's ready though. Let's see. This course is going to be good.
Good morning, Mr. Marks.
Good morning.
So you agree that studios use comps to negotiate deals, correct, with actors?
Sometimes they do.
And you have an issue with the comps that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to...
That's not my question. Are you offering a different set of comparators than what Ms. Arnold used?
She didn't offer.
I'm not here offering comparators. I'm saying what she offered are not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms.
That was my
comparisons
sir,
are where you
that
look.
was my question.
He's trying to remember. They got a time.
All right, we'll strike after that. Just
they got a time.
Mr. Marks. Thank you.
They got
Now,
a time.
you're a deal maker, correct?
Yes.
What actors have you negotiated for in superhero movies?
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd and Will Ferrell on an Apple series. Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for in a superhero movie?
For a superhero.
As I sit here now, I
Yeah, but you got all
can't
the rest
remember a
in. You got all that.
superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct? Your answer is no.
All right. So as I sit here, I can't think of a Marvel type superhero.
He's doing this on
movie
purpose to
that
take a lot of their time.
Negotiated. Although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out. What he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any testimony under oath that that's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent option contract. Correct?
He's asking questions now.
And you agree that for if there's an
He's
Aquaman
wasting
3,
their time, yeah.
Ms. Heard would have an option to receive $4 million, correct, for the movie?
Well, actually, you would
never answer just yes or
Warner
no.
Brothers would have the option to engage her.
All
If they
this is
engaged her, she
killing
would
their
receive
time.
$4 million, correct?
She doesn't have the option to refuse. They have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone.
He is.
That could be other
but
type
this is
of
a
studio
professional
movies.
witness, so he
But for
knows
for
how to waste
studio
their time. He's
superhero
wasting
movies,
their
it'd be
time.
$4 million, correct?
Yeah,
He's a lawyer,
he's a
you
lawyer.
know.
If I was
This guy knows
Ms.
he's gotta
Heard's
waste their
agent,
time.
that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that.
He's
of that
never
movie,
just saying
correct?
yes or no.
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters in movies that don't appear in the next movie.
That's true.
But a female star in a breakthrough
But if it's a
movie,
breakthrough
in a
by
superhero movie, can
definition-
you identify any actress who's not gotten another studio movie after that?
There has been
If
a
they
couple,
didn't,
though.
it wouldn't be. Not. You
Well,
wouldn't call it a
after
breakthrough. As soon as you call it a breakthrough,
Miss
they got it. They're going to head up.
Heard's breakthrough in 2018, she did get Aquaman 2.
Aquaman 2 was already, she already
Okay.
had the option for Aquaman 2,
All right,
correct?
so she did. Miss Heard did not get any movies after 2018, long before the Adam Waldman statement.
Other than Ms. Heard, can you identify any actor or actress who's
He's asked the
not
question
gotten
3
another
times.
studio movie after their breakthrough in a superhero movie?
As I sit here now, I haven't been asked to research that, and I can't. That would
Okay.
be a normal thing.
And you're not providing an alternative number for Ms. Heard's damages, correct? For the jury?
Correct. I'm not providing an alternate number. I think she's been more than adequately paid.
I'd move to strike after no, I've not been provided another number. That's all. I mean, my question was, you're not providing another number.
I think it's in fairness and the full answer to the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay. All right. No further
All
questions.
right. Redirect.
It took a lot of time.
was
Mr.
quick,
Marks, in response to some questions from Mr. Ladehaft, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long career that I mainly forget what I've done, but I negotiated all the contracts for Pinocchio, if you will, that was produced. Is Coming to America the original? Is that a fantasy movie? The Golden Child, is that a fantasy movie? Yeah, and by the way, I may have negotiated contracts, and ultimately the film wasn't made. But as I sit here now, those are the only ones that come to pass. If I was looking at my resume or going through my files, I might think of others. But
they should have been looking through it.
there isn't a
and bring it
deal
to-
that I
I'll
haven't
give you
made.
your CV with
And
that
I think you
refresh your
also
recollection.
testified in response to Mr. Nadelhaft's questions that you have negotiated some deals for Chris Pratt and Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have, but don't quote me because that's not my genre.
No further questions, Your Honor.
All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right. Your next witness.
So Depp's team today, their strategy is
Plaintiff
let's
calls Michael Spindler.
destroy
Michael Spindler?
the counterclaims. That's their. So them if they didn't it seems like their strategy was
Testified
we can't get
previously,
them
correct,
kicked.
Mr. Spindler. All right.
We're
Just
we're
reminded that you're
destroy
still
them
under
today.
oath. Okay, sir?
And we're gonna
right, thank
make
you.
them use their time to defend the counterclaim that we pretty much already won. So they're like, they're not going to win on the counterclaim, but let's
Yes,
make
sir.
them waste time to defend the
Good morning,
counterclaim
Mr. Spindler.
before we get to
Good morning.
bolstering our claims.
Can you remind the jury who you are and what you do?
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages resulting from 3 statements made by Mr. Walden?
Yes, I do.
Do you have an opinion of that claim?
I do.
All right.
Let me take down this super chat real quick. It says, Nate, I went to Aquaman and had no clue it was her. Most people I know didn't know she was her. Mira, I'm assuming. Let's be honest. Men went to Aquaman because it was a comic book. Women went to see Momoa topless. I think that's accurate. I think the problem here is that I think Depp's team strategy is let's go after the counterclaims, because the counterclaims, I'm going to put a poll in the chat real quick, and I'm assuming I already know what the result's going to be, but do you think she's going to do? Does Amber Heard win her counterclaims? And I don't think H-E-A-R-D. I don't think she does. I don't think she does. And if that's the case, here's the poll in the chat. We got to put does. D-O-E-S. Does Amber Heard win counterclaim? I don't think she does. And I don't think they've even put enough evidence to even put it really at issue. But if that's the case, my legal strategy going in here is, I'm assuming their legal strategy is, let's waste their time having them defend a counterclaim today, and then tomorrow we'll just go and bolster our claim.
Now, you indicated that you would listen to Ms. Arnold, and she testified on behalf of Ms. Heard relative to economic damages. Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yes, I have.
And what's that opinion?
It is not adequately supported, and it is unreasonable.
Very clear.
There were multiple elements to that analysis, both damages related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted relative to the film career and endorsements?
Okay, well, first of all, with respect to her damages calculation, there was no calculation per se.
There was no calculation.
Initially looked at these comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right. What is the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for anticipating future compensation.
Had you looked at Ms. Heard's prior compensation?
Yes, I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Well, once again, you want an analysis that's anchored in fact. I don't believe that Ms. Arnold has done that in her analysis. So here we've got some actual data, we've got some historical compensation, and as the last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on in your analysis as to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements that occurred in April of 2020. So 2019 is clean of all that.
What did you understand Ms. Arnold's methodology to be?
Her methodology initially appeared to be based on these comparable actors that she had identified, and theoretically, the compensation that they earned, although she doesn't identify what that compensation is or provide any support for it or any calculations.
What is your opinion of that methodology from an accounting perspective?
That methodology was unsound. It's just unsupported. There are no numbers. There's no data that she provided and support for that.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages, although it's still a little bit unclear to me, a little bit vague. But there are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television series portion of her analysis, what do you understand that methodology to be?
Okay.
Objection, Your Honor. May we approach?
All right.
So, and he's a forensic accountant. So, I mean, yeah, this is. I've been really impressed with the witnesses that Depp's team has been bringing up, and I think even just on the stand, they seem cleaner. They seem more professional. I mean, the Doc Brown guy that we had yesterday. Oh, you're muted.
Yeah, the Doc Brown guy, he was all over the place. He was kind of there. But today, this is so now looking at it from the perspective of yesterday. Yesterday, the defense put on all these experts. Today, they're putting on all these experts to really combat what you just heard. So I think the strategy from Depp's team this morning is outstanding. We're going to we're going to make them waste time trying to defend a case that they know they can't win. This is it's a beautiful strategy. I just think this is exactly what you'd want to do. Go ahead.
Well, and you see it in politics all the time, right? So in the last election, Biden would put money in states that didn't necessarily even matter, but if he can get Trump to put money defending those states like Texas, like all of a sudden Texas is in play, but Texas is already lost there. But so it's a bit of a flip situation. But what he's doing is he's getting Trump to play defense in states that he shouldn't have to even be worried about, and that's just to draw attention or take time away. But you've got limited resources. You've got limited resources, money, time, whatever it is, and if you can make them spend it in areas that they really shouldn't otherwise have to, I think I think they were already in trouble, but I think the counterclaim is murdering them because they just don't have the ability.
And I think your analogy is because and it's funny because I remember when Trump did it to Hillary Clinton, in Michigan,
Yes,
and Wisconsin.
Yes.
Next thing you know, they started spinning ads. They were like, "Oh, we can get Michigan," and he won Michigan. He actually legitimately won Michigan. But but he started putting money into Michigan, and blue state that had been blue for 20 years, she had to then go start putting money in Michigan, right? She got to start putting money into Michigan. So but again, I think here they've made this big what to do about her rising star. And that's always the problem with damages, is because you're trying to say what would have happened in the future based on what would happen in the past. And sometimes, especially when someone's in that middle of that trajectory, you don't know, you don't know. It's more, the farther you get away from the present and going to the future, the more speculative it has become. So generally, I think this expert who they have on the stand, I think his approach makes more sense, right? We're going to ground it in fact and reality. What did you make before? How are things going? And then what could we theorize would happen in the future? Amber Heard's saying we go from 10 million a year to 40 million a year from Aquaman. And he's like, no, and if you think about the counter argument to that, two things. Number one, she wasn't Aquaman, right? She was a supporting character in a $1 billion movie. What does that mean? Does that mean she gets Aquaman money? No, right? She actually, her character could be replaced. They just like, and think about this. To give you guys an example, remember the Hulk, the first Hulk in Marvel? It was Edward Norton.
Edward Norton, yep.
And they switched them. They switched out the Hulk. So these people can be replaced. So that's what I mean. Edward Norton, after the Hulk came out, he could have came in. I would have made $100 million as the Hulk. No.
Yeah.
The earnings from television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes, during 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
All right. What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2. And presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example, the analysis that Ms. Arnold did, it didn't appear to be...
Let's just look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
You're muted.
Hello again, Mr. Spindler.
Good morning.
Let's start the clock on cross-examination.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can use your terminology.
I'm sorry, there's an objection, sir. Hold on.
Can we approach?
Okay.
Yeah, because they're going to refer. They want to refer to them so everybody understands what's going on. Amber's attorney wants to refer to them as the Depp Waldman statements, so the jury can just hear it and just assume that it's Depp Waldman. So Depp's team is like, hold on, before we do this, right? You can't refer. We're going to object to that. They're the Waldman statements. It's for the jury to determine whether if the statement is a Depp statement.
Yeah.
So you can't just call it a Depp Waldman statement because there's no evidence. They haven't put anything in front of the jury to say it's a Depp statement. They're calling it that, but technically it's Waldman statements that you're trying to get that you're trying to prove for Depp. So for those of you, we talked about the Hulk earlier. I see the chat is going crazy with the Hulk. So yeah, so you had Lou Ferrigno, you had was the original Hulk, then you had what's his name?
Norton.
Norton. You had
So,
Norton.
Mr. Spindler, when I refer to the Depp Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a rebuttal.
Oh, I forgot about Eric Banya.
Opinion to part of Miss Arnold's testimony, correct?
Correct.
You're not providing opinion on whether Miss Heard saw Mr. Depp, correct?
That is true.
You're not offering an opinion as to what any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Miss Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Miss Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can be some variability.
An increase in the number of roles may lead to greater income, correct?
I'm sorry, could you repeat that? I was speaking it in here.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income, correct?
The number of roles or the particular self.
Getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
it depends.
What Ms. Heard earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Heard's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes.
Now, you're not a causation expert, right? You're just a damages expert.
That's correct.
So you're not testifying as to whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman statements, correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified thereto.
Sharp.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert
This is a
opinion
time
on
sink.
what impact
Yeah.
the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
All right, all right. So, at one thing that you I think we should all notice is that the cross-examination by Amber's team
Okay.
is
All right,
following
thank you, Mr. Finley.
all the
You have a
rules of
seat in the courtroom,
cross-examination.
or
Thank you,
you're free to
Hold
go.
on.
Thank you.
That's it for him.
All right, your next witness.
These cross-examinations are tight now.
Plaintiff calls Doug Banya, Your Honor.
Okay. Can you spell the last name for me? I'm sorry.
Bania.
Thank you.
So the only thing I'm gonna say about this though going forward is if it's a
Yeah.
breakout role, then by definition, that person is going to be doing better going forward. If they don't,
Yes,
then
yes.
it wasn't a breakout role. So when somebody says, okay, can you expect that she'd be doing better after the breakout role? Well, almost by definition, because if she's not, then it wasn't a breakout role. But that's almost already rolled into the options. I mean, the options
Very good
assume
point.
the franchise, yeah. So it's 501 or 601, half a dozen of the other. It
So
depends
you
on
can-
which way you want to look at it. But yes, of course, you can, once you admit it's a breakout
So
role,
just a
if you
reminder that
agree
you're
to
still
that,
under oath. Okay,
she
sir?
was going to go up.
Oh yeah. Here's another expert. I'm very bad. Let me use the restroom.
Good afternoon, Mr. Banya.
Good afternoon.
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics and both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes,
Were you asked to analyze their testimony and provide opinions in response?
yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell and Ms. Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Ms. Heard.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there are more than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag, we just don't like you, Amber. So then he used those hashtags and he searched through, using the Twitter API, searched through various tweets and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact, the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, were these tweets, did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail. The Daily Mail is a UK tabloid, and Mr. Arnold was quoted in three of those articles. And those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Did you show counsel?
So one of the interesting things on the last witness was when they kept saying, "So you're not doing this, you're not doing this, you're not doing this," and they had to keep saying, "Okay, you haven't," and it's important to do. But it's like this laundry list that they have to go over just to clean up, and just to clarify that to mitigate the damage from the previous witness. But it's just sucking up time, even just to say even what the witness isn't saying. So with only 4 hours left. That means what? Johnny's team has what, a 4-1 advantage in time. I don't think they should squander it, but that's some leverage. And I mean, if I were Hurd's team at this point, I'd be doing anything I could to not run out of time, so that when they bring Depp up, you can do something about it. If they can't afford to run out of time here.
1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Banya, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data that their tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. The first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of. And then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and 2%, only happened during this important period. I just continue to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Okay, yes.
This is devastating testimony.
Well,
I've been
it's all
listening
right-
to it.
yeah.
This is devastating testimony.
Yeah, I'll give you time to look at it, sir.
All of the evidence they brought in, only 2% of the time frame. The third of them didn't even happen before the statement. This is devastating to any causation. This is devastating. Let me get these super chats while we got this little pause. Good point.
All right, plaintiffs.
On the breakout row.
Microphone,
Should have
No objection as a
challenged that.
demonstrative.
Okay.
Yes, great.
All right. Plaintiff's Exhibit
I agree, Mary.
1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor.
So demonstrative means it's not going back to the back with the jury.
Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing
Yeah, that's the 2%.
various spikes.
Yeah.
As it relates to the hashtags that Mr. Schnell testified about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest,
I will.
largest
Thank you so much,
spikes
Talking
related to
Faces.
the
I definitely
hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike again happened before the Waldman statements. Woo! So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest spike, was prior to the Waldman statements. So it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here, and then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them. Well, actually, I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Wow.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together, and that's why he had these.
Which is what you'd
spikes.
expect. I mean, it
So
says
the
nothing about-
correlation
yeah.
there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements.
Wow.
And the fact that there's a correlation with the hashtags is irrelevant to this case because we're
Waldman
dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
Oh.
How do you know that
From
the
their own
correlation doesn't
data.
have anything to do with the Waldman statements?
Yeah, that's.
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. You know, if when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here. And then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyzed each of these spikes and none of them had to do with the Waldman statements.
Woo!
Is mathematical correlation the same as causation?
No.
Why not?
I mean, correlation is simply a relationship between two or more variables or two or more things. In this case, the correlation question is, when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, you know, again, Mr. Schnell provided no evidence of any correlation.
Just said
What
it.
correlation
Explained it.
opinion did he
Correlation.
provide during his testimony?
Well, he provided the correlation that the 4 hashtags, you know, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the facts that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a
Causes
change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this.
Well, they
And as a
provided
matter of
evidence
fact,
to the
during
contrary.
Ms. Arnold's testimony yesterday, she didn't even know what causation was. You know, she was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert.
She did say
We're not
that.
talking about the words. You know, when it comes to damages, you have to prove causation prior to calculating damages. You know, so there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
That's how you throw shade.
Did you hear
baby.
Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
That's two separate words.
Well, he agreed that he failed to link the spikes in the hashtags on Twitter to the Waldman statements.
Bad.
Did he try to do that?
Well, he tried to do that. But again, his analysis
What a
was
burn.
looking at the word Waldman and
That's what I was thinking.
looking at the word Waldmanian and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
We can, I think, take that one down, please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
With their own
see what else
graphics.
he did.
Again, the assignment was
this
to
is their-
determine
this is- remember, this
if
is Amber's
the Waldman
evidence.
statements were part of the tweet. So I continued to dig in,
Oh.
to the data.
He's digging into the
I believe
data.
the next step is now that I've excluded, the 35% that was before the Waldman statements, because they were irrelevant. I wanted to really analyze from the April 2020 forward to see if any of those tweets, were contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
No.
Yes, I did.
Your Honor, may I approach again?
All right. Yes,
Stream
ma'am.
is demonetized. Why?
Oh no. Oh,
Here they
have
go.
fun with that.
It's all right. It's all right.
Any objections, sir?
No objection as a demonstrative.
All right. We'll mark it for identification as plaintiffs 1295 as demonstrative and publish to the jury.
So, Mr. Bunyan, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again. And what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases.
Abuse, hoax,
and I determined that there were 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets had the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore, I eliminated any of those, and it came down with 95 unique tweets.
Wow.
And then what I did from there is I analyzed those to determine if any of these terms were in there. And I identified 5 tweets that were related to the Waldman statements.
Out of 1.2
Do any of the
million
hashtags
tweets,
Mr. Schnell analyzed include
5.
the words from the Waldman statements?
5.
No, they don't. And, because I am rebutting Miss Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Miss Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements.
Unbelievable.
5. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right. It's going to be a little while, I assume.
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen. Okay. Do not discuss the case and do not do any outside research. Okay.
This was brutal, people. This was brutal. This expert they got just essentially destroyed their whole case. Hey, Drag, I see you in the chat, man. If you want to come in, I'll definitely send you a link. Let me see if I can get my man Drag in here. But oh my God, this was.
All right, we'll come back at 1:40 then.
This was.
All right, thank you, Your Honor.
This was a disaster. This was a disaster. This was a pure disaster. That's all this was. This was a disaster. I don't know how you I don't know how you spin it. I don't know what you do for it. This was just a disaster. Out of 1.2 million tweets, let's just think about that. Out of 1.2 million tweets, only 5, count them, 5 had the Waldman statements. Crazy.
Well, and then apparently their own witness agreed that said, yeah, he's right. I didn't perform this particular analysis, which was necessary. So he was able to quote their witness as saying that he had done it properly and properly impeached their own witness.
He just destroyed any causation. That's literally destroying any causation for the defamatory statements, right? These statements are defamatory. She's saying he has all the causation of all that, but that's all destroyed. Think about this. We started off with how many tweets? We started off with like almost 2 million tweets.
Yeah, like
then
1.7
he said
or 1.9. Yeah.
Yeah. Then a third of those were we threw away, right? Because they were made before the Waldman statements, right? So he's already got the timeline wrong. So then we get the 1.2 million, right? We say, okay, here's the timeline. Then we say, well, how many of those even mention anything out the Waldman statements? He brings that down to 700, right? So we're down from 1.2 million to 700 tweets. Okay. So we're down to 700 tweets. Now, out of that 700, what actually used the words like, abuse, fraud, any of that stuff that the Waldman statements actually said? 5 tweets.
Well, and which ones weren't retweets, right? Which ones weren't just
retweets?
What was something original? Yeah, well, and what I like too was, that little downward slope right there, in my view too. I mean, it's like, obviously nobody's going to make the argument, but I'm seeing they're going based on how they're arguing and just we see a relationship, ergo one's causing the other. Those statements were helpful when the statements came out. Look, the negative comments went down, so clearly, maybe she owes Johnny money for helping her reputation, because the tweets stopped or went down when he said negative things. Apparently,
Some people were saying he said more. He said 59. I thought he said 5 tweets. It was only 5 tweets. Did he say 5?
I thought I heard
59.
I thought I heard 5. I heard 5.
Well, let me just because some people are saying maybe 59. All right, first let me get these super chats out, and then we can.
Is it going to matter at this point?
Yeah, 5 or 59. Does it really matter? Wasn't it 59 CCP? Wasn't it 59? Let me give you 59. The jury's heard there were 1.7 million negative tweets. Now you're down to 59, even if that's true.
That number is so low compared to the original. We could be off by a whole order of magnitude, and it doesn't matter.
I'll give you 500 tweets. Here we go. Can't her statements be used as her likely reasoning for losing her roles? Can't hers? Yeah, her own statements can be making it her fault. Things went downhill after admitting assault. That's true. It could be. But but the argument is whether the statements that Waldman made caused this, because that's what you're talking about, cause and effect. That's what he was saying. He's like, how can you have a witness talk about causation, and then when you talk about, do you know the difference between correlation and causation, she says, I don't know. It's semantics. And that's what he called her out just now. He was like, how can you have an expert talk about causation? And when you ask them what the causation means, they say we don't know the difference between correlation and causation. Duh, right? Big time burn for the other one. Barry on for $5 says, I wonder if Twitter just might have a bot problem after all. That's true. Let me let my man.
5 tweets to how many? Yeah, that's an interesting point.
Drag, what's up, baby?
Hey, what's going on? This is, I'm not actually in the lab. This is just a recording. I'm actually doing something in the other window.
So what do you think about what you heard, bro? What do you think about what you heard?
Well, I think it was a crafty move for Depp's team to use the evidence that's already been presented against them. And I was sort of wondering that too. I was like, well, if you would expect these Walden statements to claims to have some sort of correlation with defamatory remarks for Amber Heard, you would expect a spike in activity because obviously people are talking about it, the Streisand effect, all that good stuff. But you don't see that. And I had to actually realize that until maybe not even 10 minutes ago. And so I think it was incredibly clever for Depp's team to start sort of dismantling the evidence against Depp and Walden and anyone else that claimed that, that at some point she had been defamed and that she's owed some sort of compensation for this, because quite honestly, from hearing from the previous witnesses, she's just sort of fabricating stories for herself, for her own ego, and then trying to convince other people that these stories she's telling herself are true.
Yeah. The problem, I think right now is that it's just it's too much. Like, as a member of the jury, generally juries believe something, but if I'm catching your experts telling me there's 2 million tweets, there's 2 million tweets, and come to find out when somebody looks at the details and say, well, there's really only 5, that now impugns not only you for lying to me, but now everything you presented seems like lies, right? That's what I think that the danger here was of putting this shoddy evidence on, because it's one thing to disbelieve Amber, but if you're disbelieving everything that they put on, that's a totally different place to be in as someone who's fighting litigation. Because right now, if you can't rely on her experts, it's so bad of order of magnitude where you can say, like, even in the chat, we were saying 5, which we actually did say. Some people were saying 59. Some people we say 5. We can, 5,000. It doesn't matter. It doesn't matter. So I think it's crazy. Now, I also think this is also part of the time game, because don't remember, they only got 4 hours, and they've been crossing every witness, and they've been tight on their cross, right? Leading questions strictly. They don't let them explain. They've been very tight on that. But I think you got to go through an extensive cross of this last witness. If you're taking your counterclaim seriously, you have to cross this last witness to get some of this thing out, because right now all you got is your causation argument between these statements and the defamation is really went to shit. And if you can't get this, you got to clean this up somehow, because this is your own evidence, right? These are your own tweets. This is what you presented to the court, and it's been exposed for what it is. How do you do that? I just don't know. And let's say you spend an hour cleaning this up. Well, guess what? That's like 2 hours you just lost, and you still got 2 more days of trial to go, and you only got 2 hours left. So,
But they're in an impossible position, Nate. What would you do to try and defend Amber Heard when you know that your client actively lies about everything, even to you? How do you, and I think it's pretty clever on the team's, I guess, case to try and employ certain experts to, maybe cherry pick certain things that they find interesting that may sort of corroborate Amber Heard's story. But there's only so much they can do with someone who prolifically lies, even after listening to her own audio, tries to lie and gaslight the very jurors that will decide the fate of the case.
And is on record saying that she could get away with it if she wanted to.
Oh, yeah.
That hurts. That hurts. But it's like, even with this, why would this expert, and you should know, you should know somebody, unless you're dumb, you don't go and check the timeline. Why would 1/3 of your tweets come before the statements? Why would you even present that to the jury, right? None of those tweets should be before the statements. But 1/3 of the tweets they analyzed were before the statements were even made.
Well,
that's causation.
If it helped to show that, like, it was flatlined before, you want to show it to show what it was like. But it doesn't even do that. Because it shows the opposite. There was a spike right before. He brings out the statements. It goes down, and then it goes like, oh, let's include this data before. It's like,
no. Yeah, because they were trying. But you know what that makes you, as a member of the jury, that makes them feel like they're pulling their eyes over. They're pulling the wool over your eyes, right? That makes me see what they're telling me. They're presenting evidence not for me to evaluate, but they're trying to spin it in a way that's not consistent with what I'm seeing, right? That's not consistent. If I feel you're trying to actively fool me, I don't believe anything you're saying. And that's what I think the legal team has to try to overcome now, because now it's based on, I don't believe their legal team. Go ahead. Sorry.
But but I wanted to ask you about this because we have to remember, of course, too, that this is a defamation case. So Johnny Depp has a very high bar, especially in the U.S., to overcome that. So it's not just about do you believe her or not, but whether or not she was deliberately trying to destroy his reputation, and she knew. So it looks to me like it's getting that far. But just not believing her or her experts is the first step in that. But that doesn't, in this case, that doesn't get you all the way there. I don't think so. How far is this going towards what is in the U.S. an extremely high bar?
All right. Well, two things. First, let me just get MP real quick. MP says even if Johnny had anything to do with the statements, now it doesn't matter, right? Yeah, essentially that's what it is, right? Even if Johnny said it, it seems to not really matter because it really didn't hurt the reputation, unless you're saying it's per se, which is another issue. But yeah, so they're saying they're making a big deal that these statements caused her all this damage, these damages. And right now, that's just not the case. That's not the case from what we can see. And again, it's their evidence they put on saying that this is the case. And they just evaluated and said, well, here's what their evidence actually shows. A third of the statements were made before. And actually, when the statements were made, for a month, there was a decrease. And then after that, then you had an increase. But the increase doesn't seem to be correlated. It's correlated with the statements, but it doesn't. But they didn't even mention the statements in them. So jury dismisses damages if they find Waldman truthful. Yeah, well, they dismiss all that if they find Waldman truthful. So I do want to talk about, before we get out of here, I do want to talk about the other piece to this, is that, so we kind of have three things going on here. We have Amber Heard's, Johnny Depp's team coming into the day. They were going on two courses. Number one, if we can get her case tossed out, we could just go into our rebuttal case. If we can't get our case tossed out, we're going to fight her on her case to waste her time and then put forward a rebuttal. And that's what they seem to have done here. So they've had these witnesses set up where we're going to attack her case and force them to play defense today. They're going to spend hours, which I'm assuming they're going to spend to try to save their case. Now on the back end, they can now put on their case without being challenged. What do you guys think about this strategy of the Depp team? To force them to play defense with their little bit of remaining time to try to get free reign tomorrow.
It's a gamble. I mean, because you want to leave the jury with a certain impression. I'm sure each team has their own goals and impressions that they want to impress on the jury, right? But if you allow certain people up there, that could hurt you. The guy that they keep calling Doc Brown, I think his name is Dr. Spiegel.
Spiegel.
He's probably the last guy that you want to have up there, period, right? Because people are just sort of miffed at his general behavior. But if I wanted to leave off with someone, let's say an expert, for instance, I would pick Dr. Shannon Curry, just sort of to reiterate the issues with someone like Amber Heard and sort of how she perceives the world as opposed to other people. If she's just perceiving that she's being defamed versus there's evidence that she's done X, Y, and Z, I think that will leave a sort of taste in the mouth of the jurors that they can go, okay, we know that Johnny has admitted to some fault. Amber Heard's not admitted to anything. Here is this person who has actually seen Amber in a clinical setting, and so she cannot be trusted based on the lies, based on this clinical analysis, and based on just what we've heard from her in this courtroom. So I think that if they were to play that sort of game, that could win. But again, it's a gamble.
Let me get this super chat. Rockin' Dawkins SC says, how could the judge rule on weakening the attorney-client privilege? Please explain why. Seems it alters the very foundation of legal matters. Well, she didn't. So there's a difference. What she did, she got around it, and the way she got around it was there's an inference that it's legal for the jury to make an inference, and that inference is that Depp told Waldman. So that's the end around, right? So if they can infer that, now do they? Now the second question is that if it's legal for them to make that inference, is there any evidence that allows them to make the inference that's been presented to say we can make this inference? And the evidence that's been presented that allows them to make that inference is that Waldman was going around, he was representing Depp. That's the first thing, but that's not enough. Second is that Waldman was making these statements because of this whole litigation, right? There was litigation and he was working for Depp in litigation, and these statements had to deal with that litigation. So these were done in the course of his employment, right? But now the last piece, did Depp tell Waldman to release the statements? Do we have any evidence of that? Well, the best evidence the judge said that they have is that Depp was in the meeting when the statements initially were released by the newspaper, the Daily Mail or whatever in England. So Depp was in that meeting with Waldman when Waldman made those statements. So if that's true, then they're saying a reasonable jury can infer that since Depp is in the meeting and he just didn't say it, Waldman, who is working for Depp at that time in that meeting, made those statements on behalf of Johnny Depp.
Yeah,
which
it's
I
hard
think
to say that he was oblivious to it. They just so happened to be in the meeting with all the players involved in it, and Johnny Depp somehow missed that memo.
Yeah. So if now you can make the inference that yes, Johnny Depp told Waldman to make those statements based on that evidence, and I think the judge is right in saying that. Now, I didn't realize that Johnny Depp was at that meeting. If he wasn't at that meeting, I think we have a whole different scenario. But since now the judge has made it very clear he was at that meeting, now we got a different issue. Now it's plausible. Do I think she's going to win on her counterclaim? Absolutely not. But I think the issue now is a little different because of that. Does that make sense?
Yeah. Oh yeah.
So before we get out of here, so you guys starting off this trial, many of us, I think even you guys too, believe that Johnny Depp was going to lose, right? How'd you guys feel when the trial first started? Because I felt he was losing.
Oh yeah, no, I thought he was. Yeah. I thought it was a sunk ship.
Yeah,
but now,
same here.
But now, how do you guys feel about his chances?
I still don't know. I think the last time I sort of indicated that on the three claims, the first, the sexual assault, that one's done. Like there's zero evidence, and I think that she whole cloth made that up.
Yeah.
The second two, when it comes to sort of his role and her name being mud, that one is repetitious here, but it's a bit muddy now because there are clear indications that within the industry itself, she was already less than favorable. But do I think Johnny had a hand in that? I think most reasonable people think that, yeah, just based on his relationship with her, he probably did. But I would love to be a fly on the wall within that jury, because I think a lot of the stuff that's going to come into play is sort of how they view Johnny as being justified in anything that he may have done, including his role in the Walden claims.
Yeah. I agree. I think when I first started, there was no way. What did you think, Nick?
Well, I think juries don't like being talked down to. I don't think they like being treated like they're stupid. And I think a lot of what Amber heard, by this point, they're going to sit there and say, you'd have to think we're stupid to have bought it by this point. And I think if they can find a legal way to give it to Johnny, I think they will. So I think they want to give it to him just based on how they're people, and they're going to be people first and automatic law machine second. And I think they're going to say, you know what, this we have, if it's possible, if it's justifiable, they're going to give it to Johnny, and I think it's justifiable. So I think it's looking really good for him.
Well, with that said, if you guys like the commentary and you like what we do, don't forget, like, share, subscribe. Let me knock down these last couple of super chats before we get out of here. This is damages. Damages, issue overblown, unlikely to reach damages. I agree, but I think this is a strategy issue. Waste up their time, keep them occupied. They only got 4 hours left. They've probably already spent maybe an hour to possibly 2 already that they're going to have to spend today defending their case. That leaves them 2 hours for all day tomorrow and for the next 2 days, right? We still got Wednesday, Thursday, and Friday this week. And they're going in with 2 hours for 3 days. Yeah, they got a problem. They got a whole problem. So I think this was a master stroke to get them to spend time on useless stuff. The counterclaim that 97% of you in the chat believe is going to fit. No one thinks they're winning a counterclaim, but now they're spending their precious time defending a counterclaim that nobody believes they can win. Even I don't believe they think they can win a counterclaim. Rockin' Docket said, thank you. Makes sense now. Thank you so much. So Strategy wise, I think the Depp team's got it. We'll see how it plays out later today. I got to go pick up children. And again, we usually just only go to the lunch break. If you guys want to see me, I'll either be on Legal Bites, Joe Neerman, or Nick Recchietta. That's where I'll be doing more coverage because I got to eat and pick up children, so it's easier to watch. Oh, or I'll be on Lead Attorney. I might stop by too. For my guests, this is Nick from In Time and Dragnot. Their links are in the description. You'll see the @In Time @Dragnot. Just go down there and click on that, and it'll take you straight to their channel. Check out these guys' stuff. I'm not even going to promote it. What I'll say is click on those links, check out their videos, and check out their material. And you'll fall in love with it because Dragnot is extremely funny. Nick is extremely analytical with his way of thinking, and he goes with all of these the breaking news issues. It's a real interesting perspective, and it's a very neutral perspective, like mine, where we're just looking at the facts and evidence and trying to determine what's real. So Nick's got a great channel. Check that out. Definitely check out my man Drag again. His channel is there's no way you can watch with his videos and not laugh. But if anything left, hopefully I'll see you tomorrow in the morning again. This is just watching morning trial. Don't forget, like, share, subscribe, do all that great YouTube stuff. My name is Nate the Lawyer. I'm out of here. Peace.
See ya.
Woof.
Right on.